That's very well. Right.
Yes, Judge, I'll begin by just reading out a short statement, if that's okay.
Yes, of course.
This hearing is in the matter CFI-054-2018 before Justice Lord Angus Glennie and is being held by a video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Dentons & Co. Lead counsel is Rupert Root QC. The first and second defendants are represented by Ashish Mehta and Associates. Lead counsel is Mr. Peter Duckworth.
Thank you very much. Now, Mr. Duckworth, it's your application.
Yes.
Just before we go into the substance of it, do we have an estimate between you of time? How long this hearing is likely to take? I've seen some people say a day and some people say 2 hours.
My lord, in the CMO that your lordship will have seen in the orders bundle, it was supposed to have been listed for a day.
Right. And so, therefore, if it's going to be a day, we might want to pencil in a break halfway through the day, after, I suppose, a couple of hours. Should we just keep tabs on that and see how we go? But we'll aim provisionally for. I'm working on UK time, which is just after 10 o'clock UK time. So if we aim to have a break just after 12 o'clock or thereabouts UK time, is that convenient to everyone?
Yes, we do.
Very well. Are there any other preliminary matters anyone wants to raise?
No.
Very well. Mr. Duckworth, it's over to you.
Thank you. My lord, these proceedings were commenced on the 2nd of August 2018, when SBM, the claimant, who I may call from time to time the bank, if I may, successfully applied ex parte for a worldwide freezing order against all 3 defendants. The claim form followed 4 days later. The injunction was renewed, but none of the defendants acknowledged service. The attempts at service are set out extensively in Mr. Reed's skeleton argument, and I don't wish to repeat them here, save only to say that the methods chosen were email and personal delivery within the UAE. No attempt seems to have been made at serving the first and second defendants in India. It was known to the bank that Mr. Mehta, the second defendant, had a personal residence in Gujarat, and indeed he's given that address at the head of his witness statement, but no attempt, as I say, was made to serve him there. Neither defendant took part in the proceedings until the third defendant, Prime Energy, came on the scene in approximately October 2019, expressing the same surprise that we felt that these proceedings were in existence and not known to us. The first and second defendants' case is that they learnt about the case in October of last year, 2020, as a result of an internet search. The reason, whether that was an adequate search or could have been found out about sooner, is possibly a factual issue that may surface again at trial if leave to defend is given. But for present purpose,
sorry, pause. I don't know why my phone is on mute, but muting doesn't seem to have worked. But if that happens again, I apologise.
Thank you.
Carry on. Yes.
For present purposes, can I proceed on the assumption that, at least thus far, that it is the defendant's case that they didn't know about the proceedings until October last year? I realise that's contentious, and I'll come back to that as necessary.
Yeah.
So the question that arises, perhaps from the foregoing, is why Mr. Mehta, who has been portrayed as a fugitive from justice by the claimant, why he bothered to engage at all when he did. And there's different theories about that. One is that, well, first of all, he didn't know, so he couldn't engage. But the bank puts a rather more pejorative inflection on that. They say that the Indian Declaration of 17th of January 2020, which provided for reciprocal enforcement within the UAE and India, led the defendant, or the second defendant, to change his strategy so that he realized there was no place to hide, and then decided that he should come back into the proceedings. We respectfully suggest that that analysis is flawed, because if he was aware of the Indian Declaration, the time to engage with the proceedings would have been before the summary judgment, the immediate judgment, rather than after it, when he would be at a handicap. But nevertheless, that's the argument that is now raised. The bank says that substituted service should be good enough for all practical purposes, but we take issue with that. We say that the issue here is that a hearing has taken place and a final judgment been given in the absence of the party, and that's fundamentally unjust. Who is to blame for that state of affairs? It may merit further inquiry, but for now the fact of the matter is that the defendants have not been heard. May I from there turn to the particulars of claim to show you how the case was pleaded? If you would kindly turn, my lord, to page B7, you will find the particulars of claim.
Yes, I haven't, I should say, I haven't always found the numbering and referencing that easy to follow, but I've extracted the documents I think are relevant. So I've got the particulars of claim here.
Very well. If you have the particulars of claim in front of you, then I can refer to the paragraph numbers, perhaps in reference to the page numbers. Thank you. I think I can go straight to paragraph 12, if I may.
Yep.
When you will see that the facility agreement between the bank and the customer having been pleaded, it then goes to the factual matrix by saying that Renish, the first defendant, made 6 requests for funds to be transferred to Prime over the course of January to June 2018, and that in order to justify those requests, various representations were made to the bank, which are called the payment representations. And those, I will take you through them if I may. First of all, that Renish had concluded a sale agreement with Lanka for the supply of petroleum. Lanka is the the Indian Oil Corporation, a subsidiary of the massive Indian Oil Corporation. B, that Renish had concluded a sale agreement with Prime for the purchase of petroleum products. C, that Renish was to make an advance payment to Prime in consideration for the delivery of consignments of oil to the Khor-Fakkan port in Sharjah, which is where the defendants had their place of business. D, that Renish was then to ship the oil consignments to Lanka in Sri Lanka. And then at the last stage of the last piece of the jigsaw was that the Lanka company would pay Renish into its bank account with SUM payment pursuant to a notice of assignment and notice of acknowledgement of assignment. What that comes to essentially, my lord, is that the defendants procured back-to-back contracts with Prime as the supplier of oil and Lanka as the end recipient of the oil. And in accordance with the bank's facility terms, Renish assigned all rights to receivables under the final stage of the contract from Lanka to the bank. So that what would happen is that the bank loan would go out to pay upfront for the supply of oil from Prime, and then when the oil was delivered in Sri Lanka, Lanka would effectively pay the bank direct the sums that were due on the loan. So that is the essence of the contract, and so far so good. We don't take issue with any of this. Paragraph 13 then sets out a series of 6 payments that were made pursuant to the facility. Although in fact not all of them are set out here. The claimant, and this is something we may have cause to complain about, it has been selective and taken only the last 4 payments of 6 that were made. And we say that to get the full picture, you really need to look at all 6 of them. But I can come to that in due course. A breach of the facility is then pleaded in paragraph 14 onwards. And then there's a sequence of paragraphs dealing with all of the steps that had to be taken to enforce the loan.
Yeah.
Of course, these led to contractual claims and claims under a personal guarantee against Mr. Mehta. But for purposes of today, I'm chiefly interested and would invite your lordship to look closely at the allegations of fraud here.
Well, can I just interrupt?
Yes.
I noted that from your skeleton argument, but why am I focusing on the fraud rather than on the contractual claims? A point that you're going to address me on, obviously, at some stage,
yes,
is, well, is there a real defence to the contractual claims?
I will.
And if not, why does it matter about the fraud allegations?
Well, it does matter.
It matters in a general sense, of course, but why would you succeed in setting aside the judgment if you were liable on the contractual obligations?
Well, I will say, even if we are liable on the contractual allegations, and there are certain defences that I will mention in due course, but even if we should have no defence of the contractual claim, nonetheless, the claim of fraud has gone on record. It's the subject of a judgment, and that is very damaging to the reputation of the defendants. For that reason, if for none other, they're entitled to set aside the judgment, even if it results in the claimant, for example, amending its claim and limiting its claim to contract, and then holding on to that. That's for the future. But for now, all of the claims are rolled into one, and the judgment was given on the premise that the defendants had been fraudulent. So it's very hard, therefore, to isolate and sever, if you like, the contractual claims and let them be freestanding. The judgment is one and complete. So that's why, in short, we are applying for the judgment to be set aside.
Oh, I see.
My lord, I hesitate to interrupt. There is just one point. You've looked at the payment representations made at the time of the payment request, and those are dealt with in paragraph 12. But the more fundamental representations are the agreement representations in paragraph 9 of the PAC, the particulars of claim. And while your lordship has that before you, it may be worth quickly looking at 9A and B as the more fundamental representations, which we say were fraudulent.
Yes,
well,
thank you.
Yes. Well, I'll turn back to paragraph 9. I'm happy to do that, if I may. And there's 2 suggestions here. First of all, that there was a false representation that the loan facility was required for genuine bona fide commercial arrangements. And the second representation is that Renish intended to make repayment of all sums. I beg to comment on that, if I may, that every contracting party, perhaps even fraudulent ones, intends to repay sums due under a loan agreement, and if they then find themselves unable to do so, it doesn't automatically indicate fraud. But secondly, as regards the first limb of this, we say that they were indeed genuine bona fide commercial arrangements, and if one looks into the whole history of this matter, that proposition is simply undeniable. You have to bear in mind that this is a case where the bank spent a year courting the attentions of the Rhenish Petrochem Company, which was a big player in the UAE. Rhenish is an international company, and it had many profitable links with the big oil majors and state corporations. And the bank, of course, in the course of its approaches to Rhenish, conducted extensive due diligence into the nature of the business and to all of the contacts, so that the idea that somehow that Rhenish was perpetrating a series of fictitious commercial arrangements doesn't bear looking at. However, I've said my piece on that, and I will move on if I may.
Thank you.
I was turning to the fraud allegations at paragraph 40 onwards, and they are quite clear in terms that little a, the purported sale and all the component transactions were sham transactions, b, that none of the defendants had any intention of performing the terms, c, that all of the defendants knew it was a device intended to deceive the bank and to defraud it of $30 million, d, that they intended by their representations to induce the bank to enter into the agreement, e, that the parties conspired together to defraud SBM, and f, they each of them knew that they would not repay sums advanced under the loan. Those are very serious allegations, my lord, and I will show you how in due course, in relation to the first and second defendants, they impressed on the mind of the judge who heard the immediate judgment application, Justice Al-Madani. And it goes even further, because in paragraph 41, it is suggested that the owners and controllers of the entities, Rhenish and Prime, orchestrated the fraud against SBM. In other words, it was a very carefully laid plan and executed with great precision. Effectively, a crime ring was in operation in Sharjah at the time. Now, going on to the relief claimed, and in fact, there's another component that I haven't mentioned, and that is the banking arrangements. But I'll come to that again, I think, if I may. But essentially, the case that was put forward in paragraph 58 is that sums of money were being washed through Prime's accounts with NBK and reaching connected third parties, and this was somehow part of the carefully orchestrated fraud. My lord, if you're able to cast your eye on the table at paragraph 58, this shows the beneficiaries of sums drawn from the Prime account. And the first point to note, and I make it quite deliberately, is that the initial $11.6 million in this table was not a transfer out of the Prime company at all, but as it says in this table, an internal transfer. So far from there being an intention, therefore, to empty the account within a matter of days, which I think is the claimant's case, Prime simply recycled the funds around its internal organization. We have some difficulty in conceiving that that could in any way be indicative of fraud. Secondly, it is fair to say that 7.8 million of the dollars found their way back to the Rhenish company. That's the second row of the column of the table. But for a very simple reason, that Rhenish does trades with Prime, and it's a two-way trade. So sometimes Prime supplies products to Rhenish for which it pays. Sometimes Rhenish supplies products to Prime. This is clearly set out in Prime's own defense to the claim. And so it would not be at all surprising to find payments going back and forth. The third entity, Petro Hub Energy, is believed to belong to the gentleman who was at the material time was the chief executive officer of Rhenish, but he has his own petrol business, and that is not called into question, or was not at the time, by his employer. The remaining entities, it has been suggested that they are in some way subsidiaries of or connected to the Rhenish company, but there is absolutely no evidence of that whatsoever. The case that both Prime and we put forward is those were independent and trading entities who were entitled to be paid in the ordinary course of business sums that they were owed. My Lord, I move on from the particulars of claim, if I may, to the immediate judgment application. And the best way of doing this, I think, is this, that if your Lordship has to hand the skeleton argument that was presented on that occasion,
yep,
it is dated the 7th of September 2020.
Yep.
Do you have that, my Lord?
If you wait 1 second.
Thank you.
It's headed as an argument for the remote hearing 11 a.m. on 9th September.
Correct.
Is that the one?
That's the one. Thank you.
Yep.
So moving quickly on, if I may, to the third page of the document, we begin the substantive argument by our learned friend, Mr. Reed. And I draw your attention to the way it was put to the court, that in the first sentence, that or the second sentence, that as explained below, SBM is the victim of a substantial $30 million fraud perpetrated against it in the first half of 2018, and so on. And then 2, the fraud arose from representations made to SBM that the relevant advances under the facility agreement were required to finance back-to-back contracts by which fuel oil would be purchased from Prime, to whom the loan monies would be paid, and paid to a Sri Lankan oil company, Lanka. And well, thus far, we agree with those words, because that is factually what was happening. Those representations were true. However, my learned friend's skeleton argument then continues. The fraud appears to have involved the creation and use of fraudulent trade documents, including documents ostensibly provided by Lanka. Lord, I will show you in due course an example of one of the Lanka contracts. It's quite specific in its terms and in its presentation. It's on Lanka-headed notepaper. And what was being suggested here, in effect, is that somehow the first and second defendants in this case had forged and concocted a contract from the Sri Lanka company that had no reality at all. It will be seen that that case has been withdrawn. That allegation has been withdrawn. And the implications of its withdrawal have not yet, it seems, been fully appreciated. Moving on to paragraph 4, I read 4.1. The Rhenish and Mr. Mehta, it's common ground between the active parties that Rhenish and Mr. Mehta have committed a fraud. By the active parties, I take it that Mr. Reed was there referring to the claimant and the third defendant, Prime. I do not read Prime's defense as saying that Rhenish and Mr. Mehta had committed a fraud. I read it as saying that there is no fraud, but if there is, we're not responsible. It's their fault. That's a very different case, of course. But reading on, for the purposes of the application for immediate judgment, the court need only find that Rhenish has failed to repay the finance provided, and Mr. Mehta has failed to pay the sums owed to him under the personal guarantee. However, the evidence of trade finance fraud against Rhenish and Mr. Mehta is overwhelming, and SBM seeks a finding of fraud in order to assist SBM in the international enforcement of such orders may be made. So there the claimant set out its stall. It was saying, we're not content with a contractual finding. We allege fraud. We want to take this order abroad and enforce it in India. That was really what the case was all about. I move on to paragraph 8.3.
Why does a fraud finding help with enforcement in India? I saw the argument elsewhere that a judgment on the merits as opposed to a default judgment was important. Why is it important that it be a fraud judgment?
For example, my lord, if interim relief were being sought, or if a post-judgment freezing order were being sought in circumstances where we say it was clear that there had been fraud and there were findings to that effect.
To strengthen that aspect of the case. Yeah.
Yes.
All right.
In terms of the relief available.
Yes. So we come again to a repetition of the core of the case in 8.3, that in all dealings with SBM on behalf of Renish took place through Mr. Ahmed, that's the CEO, and Mr. Mehta, that's the second defendant. In the course of their dealings, Messrs. Ahmed and Mehta represented that funds were required for legitimate business transactions in which Renish was involved, including transactions purportedly entered into between Prime as a purported supplier and Lanka as the purported ultimate purchaser. This was important because, as SBM had made clear in its initial offer letter, it wished to finance oil trading in which the suppliers could include local buyers such as Prime, and the ultimate purchasers were major state organizations such as Lanka. It is now common ground between SBM and Prime that the latter never agreed or intended to supply oil to Lanka. Lanka itself has declined to confirm that it ever received any oil consistently with the purported trade documents. My lord, with no disrespect to my learned friend who was acting perfectly properly on instructions, those two propositions were both utterly false. It was never the case that Prime intended to supply oil to the Sri Lankan company. There was simply no connection between the two ends of the deal. In other words, it wasn't an end-to-end contract. It was a back-to-back contract, which is a very different creature. Prime says quite freely in its defense, as we would expect, we were not concerned with who the end buyer was. And so the suggestion that somehow the fact that Prime didn't intend to supply oil to Lanka was indicative of turpitude or fraud simply does not stand up. It's not even coherent. Finally, the last sentence, that Lanka itself has declined to confirm that it ever received oil consistently with the purported trade documents. That again was a false assertion, because all that had happened, at any rate to Denton's knowledge, the solicitors acting for the claimant, was that they had written to Lanka asking them to confirm whether these were genuine oil deals and hadn't had a reply. No, that's far from Lanka declining to confirm. And to make the position now transparently clear, Lanka has since, in January of this year, openly confirmed that these were genuine oil trades and that it received 3 deliveries of oil. I don't attribute any blame for that sentence to the solicitors or counsel, but the bank itself was in regular contact. Well, perhaps that's putting it a little highly. The bank, in about April to June 2018, representatives of the bank made periodic inquiries of the end consignee, Lanka IOC, to see whether all of the transactions could be verified. That's exactly what you would expect a bank to do when it's lending substantial sums on an oil deal. And what we say happened here is quite simple, that every time that Renish made a request for funds to go to Prime, the bank put its due diligence hat on, made discreet inquiries of all manner of people, looked at the documents, satisfied themselves that it was absolutely legitimate, looked at the history of the trading and the fact that the contract of loan had been performed to date, and then approved the new advance. So we're into the territory here, I fear, of the claimant misleading the court on material facts. And of course, one hesitates to say that, but in this case, I do say that. I say that there was a gross misleading of the court by a presentation that was factually incoherent and inaccurate. If I may pause here, my lord, I would just, I don't know if it's possible to cross-reference documents in the bundle on your screen, whether you're able to do that. Or... Probably.
I have a separate screen which may help. We'll give it a go.
All right then. Could I have a go at turning you to D1-847 page?
Yeah, D1-847. Is that the second witness statement of Mr. Sada?
No. It's an exhibit to Mr. Ravi Gunis's statement.
Right.
Let me at least tell you what it is, my lord. It's page D1-846 for your note.
That is Mr. Sada's witness statement, just to assist.
Sorry, that is
Mr. Sada's witness statement.
Yeah.
Then my bundle is numbered differently. I'm not talking about D846, but D1-846, which is a different section of the bundle.
Oh, right. Does it come after the D section? Okay.
It's a new tab. I'm sorry, I should have made that clear. Tab D1, page 846.
I'm nearly there. An email of 4th of June.
4th of June. This is an internal memo, my lord, in the bank, and the subject is Renish Petrochem, third deal for Lanka IOC.
Yeah.
And you'll see that the request that was being made was to grant a 90-day import loan in favor of Prime Energy for US dollars 7.4 million. And this was to be the third deal of the second contract from Lanka and the sixth deal in all of the deals for Lanka at SBM.
Right.
And if you can just glance at the next page behind it, near the top of the page, you'll see that the bank records further details on Lanka IOC end buyer.
Yeah.
And there are 3 bullet points are set out. So this is a case where the bank has done careful due diligence on the end buyer and includes that record in its internal memos when requests are being made to lend money. Turning back to the previous page again, if I may.
Yeah.
You'll see that the updates that are given are as follows. The following transactions have been successfully serviced. And then it lists a number of different transactions with its client. One assumes Renish Petrochem. And then you find the 3 prime deals: import loan in favor of Prime Energy, first deal, US dollars 9.1 million. Do you see that, my lord?
Yeah.
And then the second deal, US dollars 8.6 million, and the third deal, 10.45 million. And interestingly, there's another import loan in favor of Vertex Global, which is, as I understand, it's suggested on behalf of the bank that that's one of Renish's subsidiaries. We say that's rubbish. But at any rate, what one could see on the face of this document is that the bank itself was entirely happy that its loan was being serviced properly up to the date of this email. It is right to say that underneath that list of loans, there is a note about outstanding transactions, and you'll see that outstanding transactions included the fourth deal, which matured on 22nd of June 2018. In other words, it was due for repayment in about 3 weeks from the date of this letter, and a fifth deal, which would become payable on the 6th of August. So that's just to show your lordship just a little bit of the background. These were authentic deals that were thoroughly vetted by the bank, and the bank was not being misled in any respect whatsoever. I mentioned that the Lanka contracts were in existence in the papers, and if I may refer you in the same section to page 578, D1-578.
Yep.
This is the first of the two oil supply contracts awarded by Lanka IOC of Colombo. You'll see it's on their headed notepaper. It bears the company logo, and it sets out in terms by an email dated the 16th of January 2018 that the subject was the import of 380 CST grade oil at Colombo and Trincomalee, and giving a tender reference number, and then requesting that, setting out various email exchanges, and then saying, we are pleased to accept your offer for the supply of 72,000 metric tons of oil on a discharge at port basis at Colombo and Trincomalee during February to May 2018. There'll be 3 parcels, each of 24,000, and 3 days delivery and so on. My lord, that was the contract that was in the possession of the bank at all material times, and that the bank's own internal memos that I've showed your lordship expressed satisfaction in terms of the fact that they had been properly performed. In those circumstances, we find it quite incredible that the bank chose, not only in its particulars of claim, but at the application for immediate judgment, to present a case to the court that these were forged contracts. There wasn't the slightest evidence in support of that proposition, and it's the duty of all legal representatives and any litigant in court not to make fraud allegations unless there's evidence in support. We say that was lacking. It was not only lacking, it was simply a crater in the bank's case. Lord, there's many similar documents that I could show you, but I only want to show you a sample at this stage. So, my lord, we say that this is essentially quite a simple case. It's a series of back-to-back contracts that were financed by the bank, and they fell over when, after the fourth deal, the third defendant, Prime, failed to supply good quality oil. There was too much sulfur in the mix, it was rejected at the port, and it couldn't be shipped on to Lanka. After that...
You take this a bit more slowly.
Sorry.
Fell over after the third deal.
When the fourth delivery arrived in port, in Corfacan, it was examined by the port inspector, who pronounced that it was substandard. Unfortunately, I can't refer your lordship to the inspector's report, but Mr. Mehta's understanding is that its sulfur content was too high. This is a little bit of a flashpoint because there have been tightened regulations within the Gulf area about the supply, about the sulfur content of oil that's passed around, and suppliers have to now comply with more stringent regulations as to sulfur content. As I say, the fourth deal was rejected at port, and that position was never cured by Prime, the third defendant, even though the fifth and sixth deals were already in being and being executed.
Can you give me Can you give me an approximate date for when this happened? When the fourth shipment was rejected?
The fourth, I'm not sure of the exact date the fourth consignment arrived in port in Sharjah, but it would have been towards the end of April or the beginning of May in 2018. Lord, the remaining orders for oil were also in May, so that there was an overlap between the deals. At the time when a question mark had been raised over the quality of the fourth consignment, the fifth and sixth cargoes had already been ordered and were notionally on their way. However, to complete the story, my lord, in the way I'm doing at the moment, what next happened is, as you know from my paper and from the defense of these defendants, that that there was a malicious email that was circulated at the beginning of July by somebody who obviously had no affection for the Renish company, possibly an employee, we're not sure, because they're anonymous. But on the 9th of July, a scurrilous email was circulated to all of Renish's important business contacts at a time when Mr. Mehta, the second defendant, was out of the country attending a wedding in India. And then the rest of the story, I think you know, that the banks took fright, and one bank in particular presented a series of undated checks that meant that effectively Mr. Mehta dare not set foot in the UAE again, at least until his name was cleared. But I've slightly diverted from my course of looking at the presentation on the 9th of September. May I return to forgive me, I've got ahead of myself slightly. Can I turn to paragraph 40 of the skeleton argument to the court on the 9th of September?
40.
Paragraph 40, yes.
Yep.
Thank you very much. Here is the substantive way in which the fraud, as pleaded, was presented to court by counsel for the claimant at the immediate judgment hearing. It was said in 40 that it depended on inferences to be drawn, and then a number of matters were put forward from which the court could draw those inferences. The first point that I've already made in 40.1, it is the suggestion that it was common ground between Prime and SBM that the purported transaction, the supply of oil from Prime to Lanka, was never intended or agreed by Prime. And then counsel went on to say that accordingly the irresistible inference is that Mr. Ahmed and Mr. Mehta knowingly deceived SBM when representing that it was required for that purpose. My lord, one slightly scratches one's head at this because it appears that even the claimant doesn't understand its own case. It was never suggested by Mr. Renish, by Mr. Mehta or Renish, that the facility was required, that Prime knew that the sums, that the oil it supplied was being sent on to Lanka in Sri Lanka. It was not a supply from Prime to Lanka. It was not an end-to-end contract. They were back-to-back contracts, and in that situation, the original supplier of the oil is not concerned with where it goes to. All he's concerned is to supply the oil and get paid. Equally, the end recipient is not concerned to know where the oil has originated from. Suffice that a tanker arrives with good quality oil and discharges at port. That's all that matters. So the idea that in some way this combination of events led to an irresistible inference that Mr. Ahmed and Mr. Mehta knowingly deceived SPM only suggests one thing, namely that the claimant does not understand its own case. I go on to the second allegation in 42. Secondly, it was said the partial repayment of the first payment was, is to be inferred, calculated to induce SPM into lending further sums to Renish under the facility agreement. As a result of the initial repayment, Renish was ultimately able to procure payment up to its credit limit before failing to repay any sums. My Lord, this paragraph requires somewhat creative use of the imagination. What counsel has called the first payment was not in fact the first payment, but the third payment out of 6. And by the time that the problem arose with the fourth consignment, which I've alluded to, the first 3 payments had already gone through to the bank. They'd been repaid by Lanka under the assignment of receivables, and so far from the defendants hatching some elaborate plot to deceive the bank by making partial repayments of the facility, it's simply the mind boggles at that idea. They were simply exercising the facility in the way it should have been used, by supplying oil and paying for it. Now, next, counsel goes on to the cessation of communication and what appears to be, on the face of it, a flight from the UAE by Mr. Mehta. My Lord, this is touched on in 40.3, 40.4, and 40.5. And, my Lord, of course, that turns ultimately on a factual issue as to who is telling the truth here. Is it true that Mr. Mehta was fleeing his creditors and simply has used the situation to his advantage? Or is it true that while he was out of the country for a genuine reason, namely to attend a wedding, a storm blew up in his face and it was impossible for him to return? Well, those are heavily pregnant with issues of fact, which can only be, of course, investigated at a trial. And so we say that they are insufficient in themselves to give rise to an irresistible inference, as it was said, of fraudulent behavior. Finally,
can I just interrupt you for a second? This relates back to the malicious email of 9th July, I think.
Yes, that's right.
Do we have a copy of that email somewhere in the papers?
Yes, we do. Yes, we do. Just let me find the reference to it, if I may.
It's D1, tab 98, page 878.
Thank you. From Truth of Renish. Yeah.
Yes.
Yes.
Yes, I see. It's D1 878. Thank you very much.
Thank you.
Yep.
Now, going back to the skeleton, I'm sorry that I'm perhaps taking rather longer over this than I need. At A45, let me just get the right.
A73. Nita, is it A73, para 40.5? I think you were.
I was looking at page E14 and thereabouts.
Yeah, E15 to get to 40.5.
That's right. Yes. Yes.
The fifth apparent flight.
That's it. Yes.
Yeah. This is the same point, isn't it?
It is. I don't think I need then to say any more about the skeleton argument. I'll go straight on to the judgment that we are asking you to set aside.
Yeah.
And for this, I need to come back to tab A of the bundle, because the judgment is at A.
Well, I have the judgment printed out.
Oh, indeed, yes, of course.
I'm old-fashioned in that respect.
Yes.
Yeah.
C14, Peter.
314, is it?
C, bundle C, page 14.
C14, thank you so much. Yes, C, it's our C14, thank you very much. My lord, really the judge in this judgment does a little more but rehearse the points that have been made to him by counsel and then adopt them as his judgment. For instance, you will note that in paragraph 7, he says, words very similar to those that have already been used in Malone Friends Skeleton, all dealings with SBM took place through Mr. Ahmed and Mr. Mehta, and Mr. Ahmed and Mr. Mehta represented that funds were required for legitimate business transactions in which Renish was involved, including transactions purportedly entered by Prime, supplier, and Lanka's ultimate purchaser. That's all said. And then in paragraph 8, the judge refers to the 6 requests for payment, but limits his attention to the last 4, 1, 2, 3, 4, and then 11 he embodies and repeats what we say is the conceptual mistake of the claimant. Prime has since confirmed that it never intended or agreed to supply oil to Lanka, as had been represented to SBM on behalf of Renish. Against that background, it's SBM's case that it was induced by fraudulent misrepresentations. Well, that wasn't our case. It doesn't reflect the facts.
Your point, I think,
yes,
put very crudely, is that Prime couldn't care less about Lanka. They were selling to Renish. Renish was selling to Lanka.
Exactly. Yes. And so far from this being evidence of fraud in some way, it's exactly what you would expect with businessmen in this trade.
Mm-hmm.
Then in paragraph 13, the judge goes on to look at the NBK account. Lord, I pondered whether it would be useful for your lordship to see, but I'm not sure that it is particularly. The NBK account lists a lot of sums going in and out. And what Prime have said about the account, which, because it's their account, is that, well, yes, it was used to service deals back and forth, and yes, we made payments of round sums, and the bank never questioned that. It was just normal trading. But the judge accepted the submission that had been made to him that the pattern of payments within the bank account were characteristic of fraudulent activity. And then he goes through a number of illustrations. In 14, there's the dissipation of the money within a very short period, namely 1 to 3 days. 2, there's the use of substantial round figure sums, consistent with dissipation pursuant to a fraud rather than legitimate business activity. 3, there's certain transfers to other accounts by Prime and then back to Renish. Circular nature of the payments is characteristic of fraudulent activity. 4, substantial payments made to connected entities. 5, that the account had been virtually emptied at the end of the period that the court was looking at. Well, my lord, those are matters that the judge has relied upon in giving his immediate judgment, and we say that all of them are fragile in the extreme. This is a bank account. Until the court knows how the bank account is operated and has evidence about it, it can't possibly reach conclusions that movements within the account are self-evidently fraudulent. Let me
Again,
Yes.
that is not the judge. Those are not the judge's comments. Those are the judge's summaries of SVM's submission.
Oh, it is rehearsal of your case. I see. Yes, yes, fair enough. But yes, well, I can move on then quickly, I think, to the inferences that the learned judge draws from paragraph 37 onwards, and you'll see that these reflect very closely the case that had been argued.
Paragraph what?
Paragraph 37.
Yeah.
In the first sentence, he directed himself that fraud depends on drawing inferences from primary facts, and the second sentence that on the undisputed evidence, the inference of fraud against Renish and Mr. Mehta is overwhelming. First of all, it was only undisputed because the defendants weren't there, and secondly, we say that so far from being overwhelming, the inference of fraud was extremely weak. The judge goes on to give reasons. First, and then I've said this twice already, my lord, and I don't intend to repeat it, but the misunderstanding about the nature of the back-to-back contracts is treated by the judge as the first reason why fraud is established. Secondly, paragraph 39, the partial repayment of the first payment can be inferred to have been calculated to induce the bank to release further sums. My lord, what the judge wasn't told clearly, or at least he didn't grasp, was that there had already been 3 full repayments under the first Lanka contract, and it was an issue over the 4th payment that really led to this litigation. And then he goes through the factors that I've already noted, and whilst Mr. Reed is right to say that the earlier part of his judgment was simply rehearsing the submissions that had been put to him, here in paragraphs 40, 41, 42, and 43, and 44, he adopts all of those submissions and treats them as effectively unanswerable. 45, for this reason, the court has no hesitation in finding that Renish and Mr. Mehta conspired to defraud SPM. And then, based on that finding, he concluded, 46, that Renish and Mr. Mehta have no real prospect of successfully defending the claim, and nor could he see any other compelling reason why the case shouldn't be disposed of. Lord, we would, with great respect to his lordship, sympathise with the position in which he found himself. He had a claimant, a defendant who had apparently run away, and no defence. What would any judge do in those circumstances but grant judgment to the claimant? And so we make no criticism of the judge doing so. However, what we say is that now that the defendants have made an appearance and have put in a defence, and have put in solid reasons, we say, why they should be granted leave to defend, it's not possible now for the bank to hold on to the judgment in any shape or form. May I turn to my own skeleton argument in support of this application?
Yep, give me a second. Yep.
For your lordship's note and for counsel's benefit, this is page E89 of the report. At page E92, I deal with the specifics of the predicament that Mr. Mehta found himself in after the Truth of Renish email burst onto the scene. In fact, I can I might take it from paragraph 10, if I may, that as it happens, Mr. Mehta was out of the country on the 9th of July at a wedding. When he flew out of Dubai airport 2 days earlier, he had no idea that a storm was about to break over his head. But with the publication of the email, he was powerless to avert catastrophe. 11. Not all of his bankers were inclined to credit the spurious allegations, but one of them, Bank Mizza, was, and this caused sudden and severe problems. Like many banks in the Gulf, Bank Mizza, held in its possession a number of undated checks, or UDCs, drawn by Renish on the Bank of Baroda as security for its banking arrangements with the bank. This practice is of doubtful legality but widespread. It is effective because the implied threat of encashment hangs like a sword of Damocles over the customer's head. Unlike other banks, however, on the 10th of July, the day after the email, Bank Mizza pressed the nuclear button by presenting UDCs to the face value of 88 million dirham to the Bank of Baroda for immediate encashment, intending, no doubt, to inflict maximum embarrassment on Renish and bring the company to its knees. Inevitably, the checks were dishonoured. Further attempts at encashment were made on 14th and 19th July with the same result. And if I may, my lord, I'd like you to glance briefly at the Bank of Baroda statement, which is reference D1089.
Right. Is that D1089 or D1089?
It's D1089.
Right, thank you. Yeah.
This is, in fact, an exhibit to my client's affidavit, a statement, a witness statement rather, and you can see there that the Bank of Baroda account on the 9th of July contained credit of approximately 600,000 dirhams, but that on the following day, the 10th of July, checks to the value of 88 million dirhams were presented to the bank and duly dishonoured. And the same pattern happened on the 14th of July, albeit in a smaller sum, and the 10th and the 19th of July in a sum of 80 million. So it will be appreciated, perhaps readily, the predicament that Mr. Mehta found himself in. I return to the skeleton argument at page E92 of the bundle.
Yep.
And as I go on here in paragraph 12, it's well known to bounce a check in the UAE is a serious misdemeanor that can land the account holder in prison. Fearing incarceration, Mr. Mehta made the rational decision not to return until the dust settled. 13. In those circumstances, Mr. Mehta was wholly ignorant of the proceedings. And I say in this paragraph, no explanation has been given why personal service was not attempted at his residential address in Gujarat, of which the bank was aware because it had a copy of his passport. Turning over the page, paragraph 15, we say that Mr. Mehta was oblivious of these developments until his chance internet search revealed its existence, the existence of the judgment given by Justice Ali al-Madani. And at once he then instructed solicitors and has ever since been actively involved in these proceedings. Lord, I hope there's no issue about this, but it may be necessary for the defendants to satisfy you that they haven't sat on their hands, that they have actually acted with reasonable promptitude. And in this passage, I say that they have done. There was a problem initially, my lord, because the defendants had no funding. And they went to Ashish Mehta and Associates in mid-October, saying, this is our problem, can you help us? Of course, Ashish Mehta would want some understanding about their fees, and at that stage the defendants were unable to pay for their legal services. So what was agreed was that they would act in good faith in the expectation that a third-party funder would emerge somewhere from the woodwork and begin to pay the firm's fees. That duly happened, my lord, towards the end of December, and the first funding came in on the 4th of January, at which point I was briefed to attend a committal hearing that took place on the 11th of January. about which your lordship knows. Lord, dealing with that committal hearing, paragraph 16 and 17, for the record, you should know, and I think you do already know, that the learned judge who heard the matter, who was the same judge that gave the immediate judgment, has not yet delivered his judgment on the issues that were argued to him. We don't know why that is so, but we suspect it's because, well, I'm tempting fate here, but we suspect it's something to do with that he was not convinced by the case that was presented to him that the defendants were genuinely in contempt of court. But
I can't speculate.
No, very well. No. But at any rate, there is no finding of contempt at present, and insofar as it is suggested that we are in some way in further contempt of court or need to purge our contempt, we say that's not right. That must depend on the prior finding of the court. Lord, in paragraph 19, I set out a series of issues which are by no means exhaustive, 13 different subject headings where issues of fact arise. And Lord, it starts with the very opening words of the particulars of claim that Renish merely purported to carry on business in Sharjah and Dubai and so on. Lord, if I were to read through these, I would simply be repeating myself, but
you can take it that I've read them, but some of them I've read fairly quickly because it seemed to me on analysis the critical point is the headline allegation by the claimant that at the time you requested the loan there was no intention to carry on these various activities, and you've given an answer. I understand your answer to that, which is that there was genuine business going on.
Yes.
But if that's right, there must be then, I would have thought, subject to hearing Mr. Reed, if that essential point is right, then it would seem to me that there is a likelihood, whatever happened afterwards, of there being an argument on fraud.
Yes. Right.
Which I don't think it's the individual examples here are going to cut across that thinking.
No. Well,
pick out your best ones if you want to.
I can leave these points then just with this thought that in a fraud case you would expect the individuals, in this case Mr. Mehta and perhaps Mr. Farhang, the shareholder of Prime Energy, you would expect them to derive some personal benefit from the money stolen from the bank. But there is absolutely no evidence of that whatsoever, which is surprising because you would expect the bank perhaps to put an inquiry agent onto their tails and find out how they're living and what their lifestyle is and what might become of the money, but there's none of that in this case. So, Lord, may I then pass on quickly and assume that your Lordship has those points? I turn to the law at paragraph 21, page E97, and I ask your Lordship to think about 3 separate heads under which the defendants may come back into this case, all of which have their own codes attaching to them.
Yeah.
The first head is they were simply not present at the hearing.
Yes.
And I'm no doubt your Lordship is familiar with Rule 24.22 of the DFC rules, DIFC rules, which says just that. If you're not present, then you have a right to apply to have a rehearing.
I can't remember the precise wording. Do you want me to turn it up?
Yes, I think if I may take you to that, it will be advisable.
Right.
You'll need to look at tab F for these purposes.
may apply.
Sorry, say that again.
Critically, it says may apply. I think there was a suggestion by another friend that
I just want to find the rule. What number in F is it?
F222, my lord.
Yep.
Part 24 of the rules of this court, setting aside order for immediate judgment. If an order for immediate judgment is made,
You've got to give me a second.
Sorry.
It may alternatively be a tab 11.
No, I've got it now. It just takes a second or two to if you're downloading something you haven't been downloaded before.
Yeah.
Yes.
Right. Yep.
This is within tab 11. This is right to say.
Yep.
Okay. So 24.22 is headed setting aside order for immediate judgment, and it says if an order for immediate judgment is made against a respondent who does not appear at the hearing of the application, the respondent may apply for the order to be set aside or varied. And then 24.23 on the hearing of the application, the court may make such order as it thinks just.
Yeah.
It's our submission that this is a freestanding right. It's not complicated with all that you have to prove or coming up to a certain standard of real prospects of success. It is purely and simply a provision intended to cure the situation that can arise when there's been a failure for whatever reason of natural justice, that both parties haven't had a hearing.
But sorry, carry on.
I therefore am submitting that the threshold for the court to exercise its power under this rule is low.
Threshold to the court allowing an application to be made to set aside. Yeah. You're not suggesting that all the defendant needs to do is to come along and say I wasn't there for whatever reason, even my fault. It couldn't be bothered to turn up. But nonetheless, 24.22 gives an automatic right to set it aside. I'm not suggesting that, I don't think.
No, I'm not going as far as that, no.
What are the qualifications?
Well, the first qualification, this relates to immediate judgment rather than not attending a trial.
Right.
And secondly, there is a discretion clearly to do so or not in the court. And thirdly, the one criterion which is provided by the rule is the court may make such order as it thinks just. Obviously, if it thinks the defendant is simply playing games with the court, then it's unlikely to exercise the power in his favour. If, on the other hand, there appears to be a good arguable reason why the defendant wasn't there or wasn't able to resist the immediate judgment, then the court may exercise its power under the rule.
Is there no, you'll have to help me if there's any case law on this, whether in England or the DIFC, but the approach that I think is taken in possibly similar situation is that you apply to set it aside. You still have to show the court that you had at least an arguable point, whether arguable is technically the correct word, but at least something sensible to be said, which might
Yes.
reasonably be expected to avoid liability.
Yes, yes. Look, that obviously, as a common sense proposition, must be right. What your lordship may find helpful is to compare this with the power of the court under Part 35 of the rule book to hold a rehearing if the defendant failed to attend trial for any reason. So this is not immediate judgment. This is not attending the trial itself.
Right. So look at that.
Would you lordship?
Yeah.
You may find it helpful just to compare the power here.
Yeah.
It's found at.
I've got Part 35. Which paragraph is it?
Well, it begins at 35:14.
Yeah.
and of course, if a party doesn't attend trial, the court can strike out the proceedings. But then it goes on that under 35-16, where a party doesn't attend the court, the party who failed to attend may apply in accordance with Part 23 for the judgment order to be set aside. And then it says 35-17, that application must be supported by evidence giving the reasons for failure to attend, and stating when the applicant found out about the order. 35-18, the court will only grant the application if the applicant acted promptly when he found out the court had exercised its power to strike out or enter judgment, and 2, had a good reason for not attending trial, and 3, has a reasonable prospect of success at the trial. So yes, where it's a final trial, there's no doubt that a defendant who fails to attend for whatever reason must have a good reason why he didn't, and have a reasonable prospect of reopening the case and succeeding at a trial.
Yeah. But you say the reasonable prospect of success test doesn't apply even by analogy to the setting aside an immediate judgment in absence.
Yes, I say it doesn't apply, because otherwise provision would have been made to that effect. It doesn't even apply by analogy, because the essence of the setting aside of an immediate judgment is that an interlocutory step has been taken which is adverse to a party, which can be rectified before the proceedings have concluded. It's not a final judgment in that sense. Of course, it has the air of finality because it can be enforced abroad and so on. But in reality, it's an interlocutory step in the proceedings, and that doesn't automatically bring an end to a party's entitlement to continue participating in the proceedings. So I say that the threshold is lower. But no doubt the court, in its discretion, would say, well, you have such a weak case that you can't possibly defend this case, so we're not going to set aside the immediate judgment. To revert to my skeleton, I think I was at paragraph 23.
Yep. Mm-hmm.
Lord, sorry, mine is taking a little while to come back now.
Don't worry.
Yeah. Yes, I'm having to go about the long way. The page search isn't taking me straight to the page. But I've dealt with the first round of setting aside. The second is self-evidently that if the defendants do have a real prospect of successfully defending the claim, then they can set aside. And the third ground is that there are other compelling reasons why the case should be disposed of at trial. And I say there will occasionally be overlap between these grounds.
Yeah.
I say that under 22 that Mr. Mehta has, on the face of it, a credible reason for not attending trial. Of course, he will come heavily under cross-examination about that, and that's well and good. That's what oral evidence is for. But on the face of it, he's put forward a tenable explanation why he wasn't there. And then 23, as to real prospect of defending, well, I've already taken your lordship through that, and you know our position on the factual allegations. I refer in paragraph 24 to the case of Allied Fort Insurance and Creation Consumer Finance, and this, my lord, was cited in our position statement or statement of case was set aside. My Lord, the significance about this case is that to the eyes of the Deputy High Court judge, he was dealing with a case of insurance fraud, where brokers were simply borrowing money from the lender, Creation Consumer Finance, and recycling it into their own debts. And the judge was inclined, therefore, to say their case was hopeless, that the claimant had a fully established right to the return of its funds. And he therefore dismissed the application, or rather he granted immediate judgment, or summary judgment, and ruled that the defence had no realistic prospect of succeeding. When it went to the Court of Appeal, though, and this is paragraph 27 of my argument, it went the other way. And Court of Appeal very clear about this, and these are the passages I've highlighted. They said it's a classic example of a type of case where a judge should have resisted the siren call to bring the proceedings to an early end, and it's not the function of a judge at a summary trial, at a summary hearing, to conduct a mini trial to resolve conflicts of evidence.
Yeah.
And particularly where honesty is an issue, paragraph 81, particular caution should be exercised before depriving a party of the opportunity of rebutting allegations. So we rely on that case as providing a good lead for your lordship. Now, I've noticed that Mr. Reid, in his skeleton argument in response, says, "Oh, the attitude of the court is changing now. You get more first instance judgments where defences are thrown out." Well, I don't know if he's able to cite authority in favour of that. It seems to us, at least, that a decision of the Court of Appeal on a matter of such importance carries great weight, and your lordship should follow this guidance and resist.
I'm not indicating a view one way or the other, but all the Court of Appeal is saying is be careful. It's not saying you can't, and not saying you should.
No, it's not. It's not ruling it out.
If honesty is involved, you've got to be quite careful, very careful, not to form judgment on honesty unless you're pretty sure.
The court is saying two things, isn't it? One is that the first instance judge must resist the temptation to delve too far into the facts. If he can see factual issues, he shouldn't try and resolve them. The second is that, in any event, if a party is asserted to be fraudulent or dishonest, they should have an opportunity of clearing their name.
Yeah.
So those are two related but essentially different points.
But tell me, sorry, it's a point I don't want to interrupt the way in which you're putting the case, but you touch upon this both in paragraph 20. It's one of the bullet points in paragraph 22.
Yes.
Where you then say that SBM could have just gone for judgment on the narrow contractual claims.
Yes.
But having chosen to allege fraud, they're stuck with the whole package.
Yes.
They can't pick and choose.
Yes.
Can you explain why not?
Well, yes. First of all, the power under Rule 24.22 is exercised by the instance of the respondent who was not present.
Yep.
He may apply to set aside or vary the order.
Yep.
It doesn't give the claimant any right to vary the judgment.
Yeah.
Secondly,
So 24.22 doesn't give claimant a right.
Give the claimant a right to cut to, as it were, pass the judgment and select the bits that he likes.
Yeah.
Secondly, the claimant can't simply come along and say, well, let's keep paragraph 24 and 32 of the judgment and throw the rest away, because it wouldn't be a judgment anymore. The judgment is one whole document.
Yeah. Well, the judgment has to be read in the context of excuse me, of the claim to which it's dealing with.
Yeah.
And,
Yes.
it may be that in certain circumstances you couldn't separate out bits of the judgment.
Yeah.
But where the judgment is for a sum of money, which is put on, oversimplifying, assuming a single loan, single amount guaranteed, and the claimant goes for judgment, brings a claim based on the loan agreement, the guarantee, and also makes an allegation of fraud. Assuming there's a good arguable case of fraud, why the judge at first instance could easily say, I'll give judgment on the loan agreement and the guarantee, but I'll give leave to defend on fraud, for example.
Yes, he could. I concede that.
And when it comes to setting aside his judgment, I know it's not an appeal, but couldn't the court say, appreciate you weren't there, I was willing to set aside so much as is not obviously due, put it again rather crudely. But if there is no defence, and I'm sure you're going to tell me there is a defence, but if there's no defence to the loan agreement and the guarantee here, but there might be a defence to the fraud, why can't the court at this stage say, I'm not willing to set aside the judgment because there's no defence to the contractual claims, but I will vary it to the extent necessary to emphasise that there is leave to defend on the fraud allegations, insofar as they remain relevant.
At one level, my lord, I can see the attractiveness of such a course from the court's point of view, in the sense of disposing of as many issues as it can. But there's a problem, is there not, in that a defendant who is left with a partial judgment against himself, which presumably can be enforced, therefore, may well be disabled from conducting his own defence at the trial of the fraud. He starts at a handicap, and he may not have the resources to defend himself, and a fortiori he may not have the resources if the claimant then enforces the judgment they have obtained. At the very least, if the court was going to go down that road, it would need to extract an undertaking of some kind from the claimant not to pursue or enforce its money judgment until the fraud trial had been dealt with. Otherwise, it would have the unique advantage of, as it were, being a funded litigant to win its own case against an unfunded litigant who is deprived of the means of defending it.
I can see that if there was some, if the funding of the claimant from the defendant was not justified, but the premise is that the defendant owes the money on this hypothesis contractually or under a guarantee, in which case it's not a question of the defendant funding the claimant to bring the fraud claim against him. It's simply the question of the payment, the defendant paying what is due, and then seeing what happens in the fraud claim if it's continued with.
Well, my lord, I can see a number of problems with that analysis. If the claimant had made the election to rely on the money judgment alone, then that would be one thing. There would be no issue left, as it were, to fight over. That hasn't happened in this case. What I anticipate will be put to you by my learned friend is that, yes, his client should have the judgment on the money claim and on the personal guarantee, and then leave Mr. Mehta and Renish to their own devices. But, my lord, I ask you to bear in mind that that they've only come back into these proceedings as a result of a third-party funding arrangement. It's quite foreseeable that if the third party finds that there's a money judgment against the people that he is endeavouring to support, that he will withdraw funding and there will be no effective defence to the fraud case.
But, sorry, I probably sound very naive. The third-party funder might withdraw if there was a money judgment against Mr. Mehta and the first offenders. Then wouldn't he also have the same likelihood of withdrawing if it is clear, even without a judgment, that there is no defence to the contractual claims?
Well, there's a risk that he would withdraw, but as long as there wasn't a money judgment in force against the first and second defendants, then he could continue to fund the case on the basis that there's an important issue about Mr. Mehta's honesty or dishonesty that needs to be tried, and perhaps out of loyalty or benevolence, he would enable Mr. Mehta to clear his name and thereby the company name, but he would be greatly dissuaded from doing so if the price of his intervention was that any funds in Mr. Mehta's hands were liable to be taken by the judgment creditor. I don't know how I can put it more clearly than that.
Yeah.
It just seems to me that there's an inordinate risk in the defendant being asked to look at that solution. I will take you to lines of defence that do exist here, but before passing away from this point, I would leave it in this way, that first of all, the judgment is whole and complete and can't be set. And secondly, that if that submission is wrong, then at the very least, the claimant should give an undertaking not to enforce the judgment until the trial of the fraud case. Otherwise, the defendant is simply out of court without a fair hearing. Lord, moving on then to potential defences, of course, at this hearing, the court considers not only what's been pleaded and stated in witness statements to date, but also potential avenues of defence that may be available. My Lord, I deal with these in paragraph 58 of my skeleton.
Paragraph 58.
Yes.
Yep.
And that here there's 4 bullet points, any of which we say the defendants can avail themselves of, if so advised. One is that it's already an issue in this case, it's been raised by the third defendant, Prime, that SBM was guilty of contributory negligence. It didn't have its wits about it. It didn't carry out all the inquiries it should have done. And it may be that that would reduce at least the bank's recovery. So that's one line of defence.
You'll have to help me on that. My recollection, but it may be out of date, so tell me if I'm wrong, is that contributory negligence in contract can apply where there is a contractual claim involving negligence to complete it, but not where it's a straight debt. Am I wrong?
No.
Lord, that may be English law, but I'm not sure that it's UAE law. There is a...
Is there a particular contributory negligence act which is relevant here?
There's banking acts which, among other things, require banking corporations to comply with the laws of, with regulations and laws of the UAE. Excuse me. But there's also specific provision in those regulations about a bank's contributory negligence. And it would seem that at any rate, in terms of breach of statutory duty, a bank may be held to be negligent to its customer and have its recovery reduced accordingly. So that may be a unique remedy available to a defendant in this jurisdiction and not necessarily in the UK.
I wouldn't mind a reference to the relevant.
I'll I'll have to come back to you on that, my lord. I don't have it to hand at the moment, but I can do. Yes, thank you. Secondly, the second bullet point at paragraph 58 is there is an issue here as to whether the claimant held the necessary banking license to operate in the way that it does in the UAE. And my lord, that actually is amplified on the page immediately following at paragraph 59, where we cite the finance company's regulation, paragraph 6.1 of which, or article 6.1 of which, says the conducting of financial activities in the UAE is prohibited unless licensed by the central bank to do so. And financial activities is widely defined as including the provision of credit facilities. And in the grounds of appeal that admittedly haven't yet been embodied in relation to this aspect in the defense of the defendants, they did plead that at the material time SBM did not have a valid banking license. Sometimes that has the effect that a bank cannot recover either any or the full extent of its losses.
So where are you reading from now?
I'm paraphrasing, or I'm deducing a consequence of the finance company's regulation. I'm saying that if they were not properly regulated, if they didn't have a banking license, then they may be in difficulty in recovering their complete debt, or indeed any part of it. That's something we haven't pleaded out yet, but it would appear to be a ground that's available to us.
Do you have any evidence that they don't have a banking license, or are you just speculating as to whether they don't?
Well, it's my client's belief that they don't have a banking license. We have raised this as an issue, and it hasn't been answered. That's where I'm coming from. One would have thought that it'd be quite easy for SBM to produce a banking license if it's got one, but we haven't been shown one. So it remains a live issue until they do resolve it. It may be a point of no substance, but at the present we have concerns about this. The third bullet point, my lord, is that it transpires from the witness evidence filed by Prime that their company was, it seems, involved in what is probably illegal oil trading with Iran, and other prohibited states. If it transpires that the bank knew about that, or turned a blind eye, then it may also limit the bank's losses because of the rule that illegality in a contract can mean that sums are irrecoverable.
But if Prime were trading illegally with Iran, what bearing does that have on the transactions with which these particular claims are concerned?
Well, if the payments, as you all knows, each advance went straight into Prime's bank account with the National Bank of Kuwait. If those payments were made to facilitate illegal trades in prohibited oil sources, then it may be that the bank is unable to recover in consequence of the illegality of what it did.
So it would require knowledge by the bank, or blind eye knowledge, if you like.
Yes.
It would require evidence that the oil consignments purchased by your clients were of Iranian oil.
Yes.
Is there any evidence of that?
Yes. Mr. Sadegh goes into great lengths to explain that all of his supplies of oil, all of his company's supplies of oil, came from Iran, Afghanistan, Iraq, those sort of countries.
Right.
And he says specifically, we sourced from Iran because it was cheaper. as you would expect.
But I thought you said his supplies of oil come from Afghanistan, Iraq, and Iran.
Yes, that's right.
You would need to show it was from Iran, wouldn't you?
Yes, I believe, I'm not sure of the status of Afghanistan, but I think there may be a question mark over that too. But at any rate, Iran, we can definitely show, because he says that he is the main exporter from the Iranian Oil Corporation.
Right. But all I have is one paragraph raising a question of illegal trading. No backup material.
No, not all we have at the moment is the certainty from Mr. Sadr's witness statement that the oil supplies did come from Iran in the first half of 2018, and secondly, we have a question mark, yes, over whether the bank knew and facilitated this. Maybe they didn't, but it's not.
Do you have any evidence that would give rise to any prima facie a case to be answered on that?
I don't at the moment, Lord. If Lordship has to bear in mind, we haven't seen all of the papers in this case yet. Mr. Sadr has filed an extremely lengthy witness statement running into hundreds of paragraphs and produced literally thousands of pages of exhibits. When we requested these from the third defendant, it was refused on the grounds that we were not parties. So,
have you got Mr. Sadr's affidavit?
Yes.
Yes. Which paragraph is it of that is relevant here, and where will I find it?
Yeah. Just allow me a moment, if I may.
Of course. Yeah.
Thank you.
My lord, it's tab D.
Yeah.
Page 844.
Yes, I see. Second witness statement of Mr. Sadr.
My lord, yes.
And it's very long. Does anyone have a particular paragraph, a few paragraph numbers that deal with this point?
Yeah, just
My lord, I hesitate to interrupt, but in 2015 there was an Iran oil nuclear deal, which essentially meant that there were no longer sanctions between 2015. You'll remember that President Trump in May 2018 walked away from the Iran nuclear deal, and therefore sanctions were reimposed as of May 2018 from the US perspective, from the US side. But the relevant period, the oil sanctions were not applied. So this is, in my respectful submission, a bit of a red herring.
Well, rather than take up too much of the court time by looking, may I come back to you on this? Perhaps after the break. Thank you very much.
Yes, thank you.
Thank you. Then the final bullet point is that SB one of a number of creditors who may, and it may be that the action would be stayed because the other creditors would not appreciate being put down the queue in SBM's favour. Appreciate that this is a somewhat speculative point, but it nonetheless is a reality that Renish has creditors queuing up to be satisfied. Mr. Mehta, in his witness statement, gives details of the remaining assets of the company.
Yeah.
And says that he is trying to reach an honourable settlement with his creditors, but that obviously means that that nobody's given priority in that sense. Lord, the reference to that is page 950 of section D.
Yeah.
In the passage headed "My Aspirations for the Future," you'll see that he says this in terms, and he sets out the remaining assets of the company such as they are. The most valuable being the oil storage terminal at the Alaska depot in Sharjah, which has got an estimated value of $22 million US. And Lord, he is in active talks with his creditors, but finds, as he says in paragraph 69, that he's held up by this case because he has to deal with the allegations of fraud before he can make progress. He may also have to deal with the worldwide freezing order. That's a separate issue.
Sorry, I'm sure it's my fault. There may be attempts to deal with all the creditors together, and it may be the case that the allegation of fraud is holding up the process for orderly distribution. Why would that affect the question of or the desirability or otherwise of the court maintaining the judgment given by the judge here, but on the grounds of contractual obligation rather than fraud?
That of itself wouldn't yes, it wouldn't damage the prospects of an overall settlement with creditors, because each one could come along with a money judgment of their own, I suppose, and then there'd be discussions between them.
Yeah.
But my lord,
I'm not quite sure why I follow that this is in some way a defence to the contractual claim, because your heading in paragraph 58 is that this casts a doubt on the cast down claim in contract.
Yes, yes.
And I don't quite see how it does so.
Yes, well, I think essentially what I'm saying is that there is a problem with this creditor taking the front of the queue. And at present, you have to think in terms not only of the immediate issues we're faced with today, but also the existence of the worldwide freezing order in the background, which is actually holding up the orderly distribution of assets. We need to get this case on and tried, and the WFO disposed of as soon as possible, in order to enter into meaningful discussions with the body of creditors. So I'm not quite sure how to formulate it, but essentially we're saying that the defendants should have an opportunity of putting those factors into evidence and engaging in a process that goes beyond the confines of this case. I'm sorry that I haven't put it more clearly than that, and I'm aware of the shortcomings of that presentation.
That seems, though, to be a reason for saying that the fraud allegation the fraud judgment shouldn't stand, in addition to your points on the arguability of it not being fraudulent.
Yes.
So I can't see how it affects the money judgment under the guarantee and the facility.
Yes, yes.
But
well,
I
think I'd have to leave it there. I've made my points on those.
Yes, thank you.
Lord, I pause to ask where your lordship would like me to go from here. I mean, there's a lot more material in the case than I have gone through so far. And if I can be of
what is it you feel you haven't addressed me on sufficiently?
Well, Lord, I don't think I need to go into the critique of Mr. Sudder's witness statement. That's dealt with in my written skeleton. As far as my learned friend Mr. Reed's skeleton argument for today is concerned, I haven't gone into that. I am able to do so, and it's a question of whether your lordship would like to hear me do that in advance of him making his submissions or afterwards.
Why don't we leave that till afterwards? Because then I think there'll be
Yes.
I'll have a clearer idea of any points I want you to help
Yes.
me on, if you're happy with that.
Thank you. Yes, I'm happy with that.
Yeah. It's now 11:55 UK time. So does that conclude your submissions for the moment then, Mr. Duckworth?
Well, I think so. Lord. I may want to come back on points like severability or conditions attached to any leave, that sort of thing. But presumably your lordship will wish to form a view on the main issue first.
Or at least yes, possibly. Yeah. Very well. Mr. Reid, do you want to start for about 5 or 10 minutes, or do you want to have a short break here?
It may make sense to have a short break, my lord.
How long do you think you'll be having heard Mr. Duckworth?
Well, my lord, I may take an hour and a half, my lord.
Yes, that's fine. Very well. Let's have a break for a quarter of an hour. So if we resume at, unless you want longer to get yourself some.
Well, my lord, if we could start again at 12:30, I realise we're possibly trespassing on the indulgence of the court staff in Dubai, for whom it's later. But if we resumed at 12:30 UK, 3:30 Dubai time, I don't know if that.
Can I just check with the court staff?
Yeah, that's fine, Judge. No problem.
Very well. We'll resume at 12:30 UK time, which I think is 3:30 Dubai time. Thank you very much. Should we keep the link open or should we close it?
You can keep the link open and just turn off your camera and mic, and then you can just come back to it.
Fine. Thank you very much.
Thank you.
We'll resume then at 12:30. Are we all ready to resume, or do we need to wait for anyone to join us?
Everyone is on the line who needs to be here.
Very well, thank you. Right, Mr. Duckworth, did you want to, you've had a few moments, did you want to come back on those couple of points that you needed time to find out about?
Thank you, my lord. I would like a little more time, if I may. I apologise that I don't have the answer readily to hand. But I'm in the course of taking instructions about the regulatory position, and I'm aware that your lordship also asked for references in Mr. Sadder's witness statement to trades with Iran. Again, if I might just take a little longer to deal with that, I'm grateful.
Yes, of course. We'll come back to you at the end of Mr. Reid's submissions, and then
thank you very much.
We'll see what. Thank you. Yes, Mr. Reid.
My lord, as you'll appreciate, we are dealing with the two claims, the contractual claim and the fraud claim. Both, in fact, relate to 3 of the 6 deals. And I appreciate that we've made matters slightly complicated by having first describing them firstly as the 1st to 4th payments, and then in other documents they're referred to as deals or cargoes 1 to 6. Essentially, it's deals 4, 5, and 6 under the 3rd of the March Lanka award letter that we are dealing with. It is those cargoes 4, 5, and 6 that were never delivered, and it is the monies monies advanced to finance those cargoes that has never been paid. There is a slight wrinkle in respect of the 3rd cargo. There was a very slight delay, and that produced a relatively small amount of interest. But we can, in very broad terms, ignore cargo or deal 3. We are essentially dealing with 3 cargoes that were never delivered, and in respect of which the finance was never paid. The contractual claim I'll come to, essentially we say there is absolutely no defence. The contractual claim is irresistible, and we don't shy from the strength of that submission. In respect of the fraud claims, your lordship will have seen, because my learned friend took you to the particulars of claim, but essentially there are the contractual representations made at the time the contract was entered, and then there are a number of further representations made at the time of the payment requests. And I took you, my lord, to paragraph 9 of the particulars of claim, which emphasised that the heart of the fraud misrepresentation in this case is whether there were bona fide commercial arrangements, and we are talking here about the 3 cargoes that were never delivered, and whether there was a genuine intention to fulfill the contracts, to repay the finance and indeed to fulfill the contracts with Lanka and Prime. But essentially, was there a genuine intention to repay the trade finance? That is at the heart of most trade finance fraud cases. In some of them, you get forged documents, so the contractual documents will have been forged and they're presented to the bank. In others, it's simply that the fraudster intends to take the finance, has no intention of buying the goods that are said to be being financed, and runs with the money, if you like. And that is at the heart of what we say here in respect of the fraud. There, in respect of, just to give a very broad overview of SPM's position, as I said, on the contractual claims, we say there is no serious defence. We've seen a suggestion, the language of my learned friend this morning in terms of saying there are avenues of defence that may be available to his clients. We say essentially reveals the truth of this position. All of the insinuations of illegality are entirely unpleaded in their existing draft defence. That draft defence is dated the 19th of February 2021. They've had 4 or 5 months since they say they first knew of these proceedings to pull together a defence. You've seen their appeal notices, their grounds of appeal. This point is raised thinly on their appeal, is not pursued, is not pleaded in the draft defence. And we say it's a thoroughly bad point. There's no attempt legally to explain how the alleged illegality renders essentially in part an alleged illegality by the relevant defendants, that should in any way invalidate the contracts or make the sums unrecoverable. And similarly, we simply don't understand the suggestion that all claims must stand or fall together. That makes no legal sense to us. We say there is no possible benefit in the contractual claims going forward to trial. So on any analysis, we say the contractual claims must stand, and the judgment that rests on those contractual claims should also stand. It is, after all, where there's reference in the rules to judgment, it is, of course, referring to the summary judgment as an order, being an order that the relevant sums be paid pursuant to the contract. In respect of the fraud claims, we say there is, as the judge found, an overwhelming inference of fraud. Now, we accept, as your lordship will have seen from the skeleton argument, that there is one element on which the judge relied, which is not the case. And it is we that have brought this matter forward. It is the fact that the Lanka contracts did not exist. Now, you will have seen too in our skeleton that the forgery is not something that is heavily relied on in seeking the summary judgment. Indeed, in the skeleton, we said it appears that the contractual documents, i.e. the Lanka contracts, in respect of the cargoes 4, 5, and 6, may be fraudulent. But we didn't, in no sense, did SPM rest its case on the forgery of the documents. The fraud case has always rested on the fact that the Renish and Mr. Mehta had no intention of these monies being paid back. Now, I say there's one element on which, of the 7 factual primary facts on which the judge relied in his inference of fraud. In fact, since the judgment, there have been several respects in which his judgment, the inference, has been strengthened. And we say that there are a number of these points. Firstly, we have carried out a very detailed analysis of the bank statements. Your lordship hopefully will have seen with the skeleton an Annex A to our skeleton, which is essentially a flow of funds analysis.
Let me find it. What page is that?
It's page E72.
Hang on. Yep.
And I apologize for the fact that it's using the old nomenclature. So payment A, which should actually be a deal 1. Payment B is deal 2. and then first payment is deal 3. So the relevant ones are actually at page E73 and following. That's to say 4, 5, and 6. So in terms of the, for example, the circularity of the flow of funds, in terms of the round numbers, and in terms of the recipients, it's pages E73, E74, E75 that show the flow of funds and show that this money was, this finance advanced by our client was not being used to pay Prime for the cargoes of oil. It was being paid back in large part to Rhenish, to related parties to Rhenish, and we'll show you. I'll show your lordship how we established that in due course. That's.
You're asking me to look at these schedules. Can you just take me to one of them and just tell me what it shows and how it shows it?
Well, let's look at it. If your lordship could go to E74.
Yeah.
Halfway down the page, you'll see third payment. A title, a heading.
Yeah,
third payment, you will see 13,751. This is essentially deal 5, my lord. So this is one of the fraudulent ones. So 13.7 million is paid in on the 23rd of May into the Prime account by my client, and you'll see the reference there for that. And then the payments out on the following days. That's 23rd, 24th, 28th. So 1.4 million goes to PetroHub Energy. We say that's a Rhenish subsidiary. It's a subsidiary. Sorry, it was owned by Mr. Ahmed Ayaz, who's the CEO of Rhenish. And there's a casual suggestion that, well, Mr. Ayaz may have been doing a bit of his own trading on the side, but there's some very significant sums going to PetroHub, which, as I say, is owned by the CEO of Rhenish. Then 2.8 million goes to Prime, and we make our point as to the round numbers. It doesn't look as if it's paying in particularly for any specific item as part of ordinary trade. 5.6 goes to Rhenish. Another 1.5 million goes to Rhenish. Now, in the context of trade finance, this makes no sense. You don't borrow money in order to trade, in order to acquire goods to trade. And then as soon as the money hits the account of the purporting seller, channel that money back to the party that is seeking the finance in order to conduct trade. It simply makes no sense as a matter of trade finance. And similarly, going down the list on the 24th, so the day after the finance is paid in, we have a payment to Mr. Farhang. Now, he is the owner of Prime. We have a very small payment to Petromaster. That is a company, as we understand, owned by Mr. Farhang. And then what follows below is an analysis of the payments on, because, as I say, there's been some quite detailed analysis. So it's not just what's happened to the money as paid into the Prime account, but when it's then paid, we've then traced it on from the recipient accounts. So the transfers from Prime's AED account. So here we have 7.3 million odd is paid to Neon, which I will say is a Rhenish subsidiary, and I'll explain that later. If you want to, if you turn back to E72, so if you turn back a couple of pages, you see there a list of what we call the subsidiaries of Rhenish. In fact, I think the suggestion is that these subsidiaries were owned by various employees of Rhenish. And indeed, if you recall, my lord, the truth of Rhenish, which I think your lordship noted, one of the allegations made is precisely this, that PetroHub, for example, is owned by Mr. Ayaz, and that other employees own companies. And so with that in mind, if we go back to E74, we see so monies are coming to the Prime account, the dollar account. They go there. Some of those monies are paid into the Prime AED account. It's then distributed to Neon, which we say is one of the Rhenish subsidiaries. So you've got monies coming into Prime, another Prime account, back to Rhenish. The third entry on that table, the 27th of May, 302,000 monies paid to PetroHub, which again we say is the Rhenish subsidiary effectively, but it's owned and is admitted to be owned by Mr. Ayaz, the CEO of Rhenish. And then over page at E75, We have the transfers from Renish's USD account. So insofar as monies are paid to Renish, we then see an onward distribution, if you like. So 1.19 million is paid to Renish's dirham account. And going down the table on the 27th of May, 850,000 is paid to PetroHub. And again, that's the Ayaz owned entity, the entity owned by Mr. Ayaz, the CEO of Renish. So when you look at all of this trading, none of it makes sense as a matter of ordinary trade finance. If, on the other hand, you're dealing with a trade finance fraud, or indeed any fraud, what one often sees is a distribution of the proceeds, often in round numbers. That's a well-recognized and acknowledged indicator of a distribution of the proceeds of fraud. You often see monies being split down into smaller amounts and, in the jargon, fragmented or dispersed, in order that it's much harder to trace and recover those assets, because you can't just get a freezer on one account. You have to get a freezing injunction dealing with multiple accounts owned by multiple account holders. So all of that pattern of payments, which we have analysed, not only monies coming out of the prime account, but then the onward distributions, if you like, all of that analysis is subsequent to the immediate judgment. So he didn't have any of that to rely on. So to the extent that we need to buttress the immediate judgment, there is that further evidence. Secondly, in addition to the to the judgment, we have the ongoing discreditable conduct. So we have certainly further evidence of the discreditable conduct of Mr. Mehta, because we now know his evidence, which of course the judge didn't have before him. So the judge didn't know that there was acceptance, that he had closed down the IT, that he had closed down the offices, he had released all the employees. Now again, all of this makes it very hard for any creditor to come after a fraudster in circumstances where his offices have been closed down, all his employees have been let go, all his IT has been turned off, so that no longer can he be emailed. All his electronic records, all his emails, all his documents will have been, in the jargon, lost. And all of this is said to have happened between the 9th of July, when we had the truth of Renish, and the 12th of July, when all of this is said to have been effected. Now it is accepted by Mr. Mehta that this is a deliberate breaking of communications until, in his terms, the dust settles. So in effect, he has torn the telephones and the computers out of the wall. He knew full well that SBM had been chasing payments since June, because as your lordship will have seen, the fourth consignment was payable, that matured. It was payable on the 22nd of June. He knew that the facility agreement had a DHABI jurisdiction court, so it was obvious that any claim was going to be in the DHABI court. He could have accessed any DHABI court document on the internet. That's one of the great positives of the DHABI court, that all of its orders and key documents are publicly available. And yet he chose not to communicate. He chose not to know. It is, in your lordship's expression, blind eye ignorance. He deliberately decided that he didn't want to know what was happening in the DHABI court. He deliberately decided to break communications. He deliberately decided to close all his offices. And it is said that he did so within the space of 2 or 3 days. In our submission, that is entirely implausible. It is beyond comprehension. Thirdly, in terms of matters getting worse, or further evidence for the inference made in September by Justice Ali Al-Madani, the contempt by the first and second defendant continues. They were required within 2 days of the freezing order to give disclosure as to what happened to the funds and to give disclosure of their assets, a classic provision of information order. Now, they did not do so while they were ignoring the outside world and seeking to avoid any communications. They have not done so since they put their head back above the parapet on the 18th of October last year. They have still not done so, even, or sought to purge their contempt, even after the committal hearing in January, for which judgment is outstanding. And in those circumstances, to have been willfully, repeatedly, continually ignoring an order of this court for over such a long period without any possible excuse. I think there's some suggestion that the privilege of self-incrimination may provide some basis. But even if that were true, well, firstly, it again strengthens the inference of fraud if you're relying on that very privilege. Secondly, it would only apply once the committal application was made in, I think, the 14th of December. So it still wouldn't explain the contempt between October and December of last year. And it is no grounds, no basis, we say, for ongoing contempt in willfully, deliberately refusing to provide information and an affidavit evidencing that information that has been made by the court. So again, a further primary fact on which the inference can rest. And finally, in terms of the explanation, we do say that.
So what explanation?
Sorry, the explanation as to why it is that Mr. Mehta suddenly reappears on the 18th of October 2020. Yeah. We say, as is canvassed in the skeleton, that you have a concatenation of events. You essentially have, in January 2020, the Indian declaration of the Ministry of Law and Justice, essentially opening the door to mutual enforcement of judgment between the UAE and India. And we say that was a game-changing, landscape-changing innovation, and the combination of that and the immediate judgment on the 27th of September meant that there was a real prospect of enforcement against Mr. Mehta, who we know to be a very wealthy individual. His statement of worth suggests he has assets of $63 million. And in those circumstances, he had to have a change of strategy. It was no longer beneficial to simply ignore what was going on in the DIFC. He felt that it was strategically better at that point to reappear and to re-engage, or to engage with the proceedings in the DIFC. And your lordship will have noticed there is a very marked conflict in terms of what he says as to how he discovered it. In one document, and we'll look at this, he says he was tipped off about the DHC. In another document, he says it was a chance search of the internet. So he doesn't say it was pursuant to a tip-off. He says by chance he was searching internet. Now, both of those in our submission are flatly inconsistent. And again, a yet further indicia of fraudulent conduct. Well, I could take your lordship through the background. I'll try and pick out what we say is of importance in terms of the background. The negotiation, the initial meetings were in Mauritius. I can give your lordship the reference, but D177. So Mr. Ayaz, the CEO, flies to Mauritius, and there are meetings, and he has to, and then there are months and months in which Renish is working hard to satisfy all of the due diligence requirements of SBM. Now, I raised the fact the Mauritius meeting just because, again, it makes it even more implausible, this licensing requirement. If a bank in Mauritius, which undertakes no marketing activity outside Mauritius, certainly none in the UAE, relevant marketing activity, it lends to a Sharjah free zone entity, it seems extraordinary, the suggestion that it should require a license to do that. Banks operate internationally, lending to clients internationally, without being required, unless they are actively marketing in particular territories, or unless they are dealing with consumers in particular territories. And I speak broadly as a commercial practitioner. it's bizarre to suggest that a bank lending internationally in these circumstances, where it has been courted in Mauritius, would be required to deal with licensing requirements in the jurisdictions of clients to whom it is lending in those circumstances. Part of the during the negotiation, we saw this statement of worth of Mr. Mehta. That's at D1 17, page 17. Sorry, I've got a missed reference. Bad reference. Can I come back to you, my lord? But I will give you his worth is stated to be 231 million dirham.
231 million.
Which is $63 million.
Yeah.
And in terms of the agreements, your lordship will have no doubt seen the facility agreement, but the aggregate credit limit is 30 million. So we do say that the initial, sorry, I've been given the reference as D179. I'm grateful to Mr. Hogan.
D1.
D179.
I see.
That's not working. Hopefully we'll get we'll sort that out and get the correct reference, but it isn't D179. In terms of the facility agreement, as I say, it was 30 million, and we say that if you look at the first three deals, which are under 30 million, they build confidence, and that what the position, the indebtedness that then arises under the 4, 5, and 6 is brought up to the maximum extent of the facility. Again, in our submission, that is redolent or fraudulent activity. Their confidence is built. I've just had a correction. It's file D1, page 179. I hope we've got it this time.
Since you've given it to me, I might sort of look it up.
Yes. We've got it right this time.
Give me a sec. Oh, this is the personal net worth statement.
It is, yes. So we're talking about the worth of Mr. Mehta.
Yeah.
So this is evidence that he provided to the bank in seeking to justify his personal guarantee as security for this facility. So in terms of the drawdown, in Mr. Garness's first statement, there are some very helpful tables. If I could quickly take you to bundle D.
Yeah.
Page 832. Does your lordship have that?
Really? Yeah.
And if I could take you to the table at paragraph 50, so you see across the first row the 6 deals, and then in the next row the Lanka, the 2 award letters, and then the delivery dates, the periods of those dates, the prime contract date, and then the delivery date of those. So that gives you some background in terms of the 6 deals, as I'll now refer to them. And then if I could take a look on to page 843.
Yeah.
There you have the first to sixth deals on the y-axis, on the vertical. But this table is helpful in showing all of the amounts of each of the advances, and then the maturity dates of each.
Mm-hmm.
And so the fourth, which was, it's the fourth, fifth, and sixth that were never repaid. It's the fourth, fifth, and sixth that were never, there was no delivery ever to Lanka. And therefore you'll see the amounts of the last column, the principal amount owing in dollars plus interest. And NA indicating the absence of any settlement. So those are helpful tables. I've taken you to Annex A, showing the flow of funds in respect of each of the first to sixth deals. Lastly, in terms of documents that will hopefully assist your Lordship, there is a cargo analysis, and that's at bundle E. Your Lordship could turn to that.
What page?
Page 119, Lord, and following.
Yeah.
And you have there 6 pages, a landscape table for each, cargoes 1 through 6. And then if I could take you, for example, to cargo 4, which is the first fraudulent cargo, you see in the left-hand column the various items in black. So those come from Renish and SBM documents, and then in blue come from Mr. Sarge's statement. It's actually his second statement.
Yeah.
So as you'd expect, the shipping documents, which are in blue, for example, debit note, bill of lading, date for payment, all that is in blue. That comes from Mr. Sarge from Prime. But the more banking, the package of documents presented to the bank are in black. So the pro forma invoice, utilization request, application form, promissory note, notice of assignment, etc. So that shows how the information meshes to provide you with a fairly, hopefully, as much information as we can in respect of each of the cargoes.
Mm-hmm.
And your Lordship will have seen there is partial repayments, and we saw that in Mr. Gunnis's in the table in Mr. Gunnis's witness statement. There is also a schedule of interest calculations which is worth looking at, and that is still in bundle E, page 82.
Yeah.
So the first one is called the first payment. It's in fact cargo 3. So this is one of the 3 genuine cargoes. And you will see there was a very slight delay in payment. As a result, some interest arises. And they simply stopped charging that in February of 2019, and that was $5,000, so a relatively small amount. And then we have what's called the second, third, and fourth, which are essentially deals 4, 5, and 6. So these are the fraudulent deals. You will see in the credit columns the very small repayments that were made at critical periods. So, for example, a small payment is made on the 26th of June. That's the $68,000. That, of course, was the maturity date. So as at the maturity date, what Renish is trying to do is reassure the bank, SBM, into a sense that it's trying to repay, that it's offering a small amount, and that small amount is paid. But essentially, the large capital amount is not repaid. Similarly, in respect of at page 84 within E, what's called the third payment, which is in fact the 5th deal. Again, I really apologise for the confusion of numbering. This is cargo 5, and there is a small repayment of $15,000, And then over page E85, there's a repayment, a credit in respect of a set-off. So there was a security deposit, which was then set off against the debt on the 11th of March 2020. That's not actually a payment, as I say, it's just a set-off. And then in respect of the fourth payment, so-called, in fact, deal 6, there have been no repayments whatsoever, not even the trivial amount. And that's understandable because there's no benefit in making a small repayment, because you're not, at that point, the fraudster isn't trying to lull or encourage its victim to do anything or not to do anything. There has been there's a suggestion in the Learned Friend submissions that essentially everything was going normally fine until a cataclysmic event on the 9th of July. That's to say, the email, the Truth of Metish email. And it was that caused the business to be closed down within 3 days. Now, we say this makes no sense at all. If you look at the reality, there had been a much earlier default on deal 4. And that problem emerges in mid-June. And if I could take your lordship to bundle D1, page 868.
D1 868.
Lord, yes. Does your lordship have that?
Yep.
So there's an email at the bottom of the page from SBM to Renish saying, second line of the email, please note that the bill under for USD 8.45 from Lanka is due on the 22nd of June 2018. So we're saying that's the maturity date. We expect to be paid the fourth repayment. And then that precipitates on the same day a response from Renish saying, due to rescheduled delivery, kindly arrange to provide 30 days extension for the same. Thanks for your understanding in advance. Now, your lordship will be aware in trade finance to simply on demand, without any substantial explanation, 30-day extension is pretty extraordinary. The reference to a rescheduled delivery, there's no reference to any sulfur issue, which is an issue that pops up very late in the day in the draft defence. Essentially for the first time. Certainly no reference in these emails. And then the page before that, page 867, one sees the response of Mr. Malik, who's the head of international trade finance. And that's about 2/3 of the way down the page. Vidisha, please note we will not be able to extend, especially that the request comes only a few days before maturity. So made absolutely clear that there will be no extension. In fact, there is an extension of 3 days. As a favour, as a matter of goodwill, but effectively thereafter one has silence from Renish. One has no attempt to excuse, no attempt to explain, and then on the 9th of July, the following month, one has the Truth of Renish email. I think we've looked at it this morning. Essentially, that is said to be the cataclysmic event that prompted Mr. Mehta to close his business until the dust settles. Now, actually, if we could just look at that, because we're in the right bundle, we're in D1, so it's at page 878.
Yeah.
So paragraph 1, well, I make a general point. Firstly, it's poorly written. It's obviously malicious. The first paragraph refers to illegal activities.
Can you bear with me a second? For some reason, it's not producing the first page. But give me a second. Does it appear anywhere else?
I don't think so.
For some reason, I can't.
878 D1.
Yeah.
878.
I've got it's in a 2-page exhibit at 879, but not 878.
Lord, shall I read out the relevant sections?
Yeah.
So I hereby putting facts of Rhenish Petrochem Group, i.e. Rhenish, ESCO and Alaska, about their illegal activities. And then the third paragraph, in their company, each employee is owner of one company, i.e. Neon Petrochem, Varun Petrochem, PetroHub, etc., and some others. So your Lordship will recognise that at least 2 of those, Neon and PetroHub, are companies that have been identified to by Mr. Sadder as being what I'll call them effective subsidiaries, so owned by the employees. So it's consistent with that. But for these purposes, we would ask, is this event, is this email so catastrophic that the business of Rhenish, which, as my learned friend rightly said, it's a very substantial business. We can look at the 2017 accounts, but it's making very substantial profits, in excess of 50 million dirham profits a year. It has very substantial net assets. Is this email, can it really be credited or suggested that it is so catastrophic that the business, that thriving business, had to be closed in 3 days? And our second point is that we say it is clear once Mr. Mehta absconds and pulls the telephones out of the wall that he has no intention of honouring his obligations. That indeed is why he is closing every aspect of his business, closing its IT, closing its phones, closing its offices, and releasing its employees. He can't possibly at that stage have any intention of repaying the monies to SBM or honouring his contractual obligations. The issue is, when did he form that intention? So the issue really is this document, this email by itself, enough to be a turning point in terms of the intention, or was the intention always and already there? Indeed, was it there when Rhenish entered the contract? That, we say, is at the heart of the case as to whether Rhenish intended to honour its contractual obligations, the issues, as I say, that are raised in paragraph 9 of the statement of claim. And we say that the intention to abscond, that the strong inference is the intention to abscond, the intention not to pay, was not the product of this flimsy, malicious email. It was the product instead of a plan that is further compounded by the evidence, in particular of the flow of funds, of the absconding, of the contempt of court. When you look at all of those circumstances in the round, as the judge did, and as one can do even more clearly now on the further evidence, that inference is, as the judge says, overwhelming.
Can you just help me on one thing? After the Truth of Rhenish email, which I've now got on the screen for some reason, after that, we're told that one of the banks called in 93 million of post-dated checks.
My Lord, yes, it sought to cash those checks. That's certainly true, and clearly those checks were dishonoured.
That arguably might be enough to bring the company down?
Well, it wouldn't, and it wouldn't for this reason. In 2009, it used to be the case, my Lord, that if you bounced a check, that was a criminal activity, and the public prosecutor would then take over an investigation. After the global financial crisis, that could no longer. Your Lordship may remember pictures of cars at airports, but after that, DHABI couldn't proceed on the basis that every bounced check was a crime that required the public prosecutor to investigate. There was a decree in 2009 which set up a committee for the resolution of disputes in respect of checks that had been dishonoured. So it ceased in 2009 being a criminal matter. So whilst it's a matter of sort of folklore, if I can call it that bouncing a check is a criminal act in Dubai, that is no longer the case, and it has no longer been the case since 2009.
Leave aside whether it's criminal or not. Bouncing checks to the value of 93 million, or whatever it is likely to affect one's credit.
that is true, but what one would expect, if this is the way, if Mr. Mehta so felt, that he would have returned to Dubai, and to the extent that there were arguments in respect of whether the checks had been properly presented, he would have made those arguments on the committee for the resolution of disputes in respect of checks. The fact that check bounced in that way was not going to destroy by itself going to destroy the business. It certainly does not merit absconding and staying out of the jurisdiction. There is no need to run for the airport in Dubai if you bounce a check. An honest businessman who was not involved in a fraudulent enterprise, in our submission, would have returned to Dubai, would have dealt with the issue of the Bank of Baroda presenting those checks, would have dealt with the creditor claims, and if the business wasn't going to survive, would then have dealt in an orderly way with its creditors. And if that was an insolvency, then they would have dealt with it in that way. But simply in the space of 2 or 3 days, because the Baroda checks are said to have been bounced, I think, on the 10th. So by the 12th, the entire business has been closed down. That in our submission beggars belief. In our submission, when one looks at the accounts, the statutory accounts of Renish, it is a very substantial international business. It is not a business that could have been closed down. And the fact that it was closed down in the way it was, with the IT being turned off, with the loss of all emails, with the loss of access to emails, with all the employees being released, with the offices being physically closed and locked, that is not, in our submission, the logical consequence of an obviously malicious email being circulated and one creditor seeking to enforce its security by presenting checks. We say that what happened is far more indicative of fraud than it is of, as I say, a proper honest commercial reaction to that email and to the circumstances of the checks. The consequence, we say, of the Truth of Renish email is that SBM resumed its chasing, and we see that at D1-880.
Yeah.
So, dear the Judicial Trustee Email, please let's have an update on below mail pertaining to the bill of 8.85 million. That was the SBM response. It wasn't panic, or it was simply, well, we would like to know, we'd like an update on this sum that in respect of a facility that matured on the 22nd of June, extended to the 25th of June, but still hasn't been paid. And 3 days later, on the 12th, the SBM emails Mr. Mehta. If you just turn on to page 886 in the same bundle.
Yeah.
So this is Mr. Malik, again, the Trade Finance Director of SBM, on the 12th of July. Dear Hitesh, we spoke. We appreciate if the below amounts could be settled by tomorrow. They're outstanding. They've been outstanding in our books for over 2 weeks. As for systems, you'd highlight there was a delay in the shipment. So again, no reference to sulfur issues, just a delay in shipment. But the shipment was due on the 9th of July and the payment would happen on the 12th of July. Well, again, so there has been no payment. Of course, what's actually happened is by this time the emails have already been closed down. So there's no response of which we're aware from Mr. Mehta. But what we do have is a WhatsApp, and that's at page 894.
Mm-hmm.
So this is Mr. Malik, the International Director of Trade Finance, on Thursday, the 12th of July. So in fact, the office has already been closed down. Can you do me a small favour, please? I need to sort out the amount due on Lanka Oil. It's about 8.5 million. I appreciate your support. Mr. Mehta comes back. Monday, I will be back with all solutions. That's Monday, the 16th of July. And then further discussion about if you need extension numbers, let me know. Let's have a quick chat later, sir, as I wanted to share another thing with you. Do you have access to your mail? Mr. Mehta's response, yes. So he's suggesting we can continue to discuss this by email. And Mr. Malik comes back, okay, we'll mail you a bit and then we can chat. So two things. Firstly,
this is what day?
This is the 12th of July. So 3 days after the Truth of Rhenish email, Mr. Mehta is giving reassurances to the bank that there will be solutions the following Monday, presumptively when he comes back from India, and that he has access to emails. No suggestion that he has already closed the offices, he has already closed the IT, that he's already let go of his staff. And thereafter, there is no further communication from Mr. Mehta. This is the moment when Mr. Mehta goes to ground. Now, we say the absconding is very powerful evidence. There is no basis for an inference of fraud. There is no explanation as to why he could not have dealt honestly with these matters, or indeed with his insolvency from India. Even if he's right that he was nervous about getting on a plane, that there would be criminal consequences, he could have dealt in an orderly and sensible manner with his creditors from India, as he appears to have closed down his offices from India. The idea that you simply go to ground until the dust settles, whatever that means, for however long that means, and that is honest commercial conduct, we find startling. And indeed, he said he was going to go to ground until the dust settled with a view to starting again. So the suggestion is that that these creditors would lose interest. He would at some point return and start trading again. And for your lordship reference, that is D. Page 940 at paragraph 34. I don't think I need to turn that up because we've got limited time.
That's Mr. Mehta's affidavit, is it? No, sorry. What is that reference?
I'll just look at it. D 940. Yes, that's his.
The witness statement. Yeah.
Yes. Now, in terms of the closing down of the business, there was a very extensive analysis by Dun & Bradstreet, again in May 16, when the facility was being negotiated. I'll give you, lordship, the reference to that. That's D1, page 45. Again, what it suggests is, as one would expect, is a successful, growing company. We have the 2017 accounts in bundle D. And those are at page 328.
D 328.
Lord, yes.
Yeah.
If I could ask your lordship to turn that up quickly. On page D334, we have the P&L.
Hang on, I can't.
Yeah, sorry.
This takes time. It's a particular page in which I can't get quickly.
If I could take you to 334, that avoids the.
No, it doesn't. No, I've got D17 to 420 all in one exhibit.
Ah.
I have to rattle through it. So if you want to take me there.
Yes, my lord. It's D3.
You have to wait a minute.
Of course.
What's the point you want to take from it while I'm finding it?
Well, at D334, one has the profit and loss for Rhenish in 2017, which is 50 million dirham in terms of profit. And then over page we have essentially the net assets or the shareholder funds. They are 752 million dirham, which, my lord, is more than $200 million. So this is a $200 million net asset business. This is very substantial. We know from the Dun & Bradstreet report that it has 43 employees. And yet the suggestion is that this was all essentially wound up by the 12th of July. And just to make good that point, if we could go to B, I apologise for switching bundles.
B what?
B, page 150, Lord.
Part of the grounds of appeal.
Yes, Lord.
Yeah.
So I'm looking at paragraph, I'm going to say paragraph 17.1. Non-receipt of service by email. Mr. Mehta, the sole shareholder in the share capital of Renish, and who was also an active participant in Renish's businesses, had to stay back in India. Owing to the adverse circumstances, it was deemed impracticable for Renish to continue, leaving Mr. Mehta with no choice but to terminate employment contracts with his employees and, in principle, close Renish's business temporarily. Mr. Mehta was able to arrange payment of salaries, end of service benefits for all employees of Renish. Around the 12th of July 2018, the registered offices of Renish shut. As no business activities were being carried out in Renish's offices, the email service also became inactive at some time. Owing to this, all professional emails of Renish stopped working and were inaccessible. For this reason, the freezing order was never received on email by Mr. Mehta. So there we have it. The 9th of July, we have the truth of Renish email. The 10th of July, we have the checks being dishonoured. And that is said to be the factor that decided the decision to close down. By the 12th of July, we've closed the offices, we've closed the IT, and we've released and paid off all of the staff. In my submission, that strains credibility to an extraordinary extent. This analysis Mr. Mehta went from being an honest businessman who intended to pay repay all of his finance to SVM, to a man who was closing down his businesses because of that one incident. The truth of Renish email in our submission is frankly incredible. And we make the further point that it's a deliberate decision to turn off his communications. To the extent that you decide not to look at or to close your emails or to close your telephones, you can't then seek to rely on the fact that someone hasn't informed you, or that you haven't discovered, you haven't got information about, because you have deliberately avoided being informed of relevant circumstances. And the only secondary explanation provided by Mr. Mehta is that he had some form of breakdown. We have the language of psychodrama that is used consistently in his witness statement. And in broad terms, between pages D 940 and 943, I don't think I need to read them, that in his own terms, he went in on himself. He couldn't bear to face the world. He cut contact with the outside world. That's very revealing language as to why he didn't know of things, or why he didn't know of the DIFC proceedings. He was well aware that the SVM debts had been accelerated. The acceleration notice was, as it happens, copied to his Gujarat address. He was well aware that there was a DIFC jurisdiction clause in the SVM facility agreements, and yet he claims not to have known of what was happening in the DIFC courts until a chance internet search, or until a tip-off, when he realized that not only were DIFC judgments enforceable in India, but that there was a summary judgment, there was an immediate judgment that had been entered against him. And we say in those circumstances, this psychodrama has all the hallmarks of complete unreality and being an attempt to explain what is clearly a highly suspicious circumstance, and one which, when combined with all of the other circumstances, provides a very strong basis for that inference of fraud. There's none of that evidence as to the psychodrama in any way mitigates the evidence as to his absconding. And then we're told that the sudden awareness that he suddenly became aware in mid-October, conveniently within the 3-week period for him to appeal the immediate judgment. And there are, as I say, 2 explanations. Firstly, that he had a tip-off, and the page reference for that is D page 943. If we just quickly look at that.
D943.
Yes, paragraph 50.
Yeah.
The first line of these proceedings is when, after a tip-off in mid-October 2020, I carried out a Google search. And then in his proposed defense, which is in bundle A, paragraph 12, sorry, page 39.
A39. That's the implication support a set-aside application.
Yes, and if I could take your lordship to paragraph 12.
Yeah.
This background explains why neither defendant knew of these proceedings until a chance internet search on in mid-October 2020. So he can't even get his story consistent as to whether he was tipped off or whether he was conducting a chance internet search. So the circumstances in which he suddenly re-engages with the proceedings, that again we find further suspicious.
Yeah.
And then we have still in the chronology, we have the worldwide freezing order. By this stage, of course, the offices had been abandoned. And we say the inference of fraud was obvious. The DHABI court agreed to a limited extent in giving us, because obviously there was an allegation of fraud made in justifying the risk of dissipation. So that point was accepted by the DHABI court in giving the worldwide freezing order. And the worldwide freezing order was accompanied by a provision of information order. I don't know if your lordship wants to turn that up, but essentially within 2 days, Mr. Mehta and Renish were required to provide information with respect to where the funds had gone and and their assets. I can give your lordship the reference. That's C, page 4.
Mm-hmm. Well, now you want me to turn this up?
I don't think your lordship needs to. And if your lordship's read it, then
what are you giving me this for?
This is the contempt of courtman.
Yes. Why are you giving me contempt of court stuff at the moment?
Well, I've just been giving you a broad chronology of what's happened, bringing out, as I say, the points that I want to bring out.
Okay. What are you bringing out from this?
Well, in page 4, if your lordship doesn't need to look at it, because your lordship's familiar with a freezer, and your lordship therefore knows that there will be a provision of information order attached, then but if not, that's at page 4 within bundle C.
Yeah.
So, so paragraph 292, respondent must, within 2 days of service of this order, to the best of its ability, inform the applicant solicitors what has become of all the sums transferred, including the identity of the recipient, the date, which sums were transferred out of the NBK account, and the previous paragraph.
The reason I was asking you about this is this going to the question of whether he knew of the proceedings and ought to have turned up to defend them, or is it going to the question of whether his general state of honesty so to support the initial fraud application?
Well, it's both. Clearly, the ongoing contempt of court is powerful evidence, we say, of his discreditable conduct, but also while we're looking at it, your lordship can see the substituted service provisions also at paragraph 24, scrolling down the order.
Right.
And you'll see the various email addresses there, including Mr. Mehta's at paragraph 24B, and that's MD, presumably for managing director. And service, so that affects service on both Mr. Mehta and on Renish. Now, you will see references, there's no bounce back from that email address. So we presume that the email was in fact received on that email address. And so that's as a matter both of, well, firstly, it's formal service because the substituted service provides there's a deeming provision, so that he was validly served with the worldwide freezing order. And secondly, he was informed of it because we didn't get a bounce back, and we believe that the service was received at that email address. In any event, the order was delivered by hand to both Renish's office address and Mr. Mehta's Dubai address. Now, that was his own personal property. That was owned by him, so he couldn't have disposed of it that quickly. And we suggest it's highly unlikely that he would not have had brought to his attention mail received at his domestic address. That was still his property.
Mm-hmm.
And you will have seen Mr. Mehta continues, bizarrely, to insist that there's no violation of the worldwide freezing order. Sometimes one sees this with respondents who, for example, are challenging jurisdiction. They think, well, I don't have to provide information until jurisdiction. None of that's true. Clearly, if you're required to provide information within a certain period, you're required to provide information, even if you have some jurisdiction challenge or whatever. Mr. Mehta doesn't have any such jurisdictional challenge. He has been subject to this order. He has failed for a number of years to provide.
Mr. Reid, this is all before a different judge on a different application. He's reserved judgment on it, or I think.
My Lord, yes, but we do rely on it to some extent in terms of the general credit of Mr. Mehta, that he is.
If your case, sorry to interrupt you, but if your case turns on inferences I should draw from the general credit of Mr. Mehta well after the event, in relation to the freezing order and so on, then it's bound to be an arguable point, isn't it? It's not a summary judgment case then.
Well, I don't. In terms of whether there is real prospects of defence, I'm not sure. Your Lordship has to put yourself strictly into the position of the judge. It's not an appeal of the judgment. I think your Lordship has to exercise his discretion in view of the circumstances as they are before your Lordship, when your Lordship is asked to set aside the historic immediate judgment.
Right. But I mean, if you're trying to use this to support the allegation of the fraud, which you rely upon as your fraud claim, then, well, I'm not sure it's going to really help me very much.
Well, it helped the judge because it's one of the judges.
The judge didn't have Mr. Mehta present before him. And now we've got the information. We've got his story. You say it's rubbish. We've got that story. I'll have to form a view as to whether it gives a realistic prospect of success or whatever the right test is.
My Lord, yes.
I suspect I'm not going to be helped that much by hearing how he didn't provide information in response to the information part of the freezing order.
My Lord, yes.
Because he says he didn't get it, and right or wrongly.
Well, my Lord, by the 18th of October, he clearly did have it.
So by the 18th of October, he had it, yeah.
And he can have under no doubt that he was under obligation then to provide information as to his assets and to what happened to the money. He has done absolutely nothing since the 18th of October to confirm that.
But does that help me to decide whether at the beginning of the whole transaction, he was fraudulent in the sense that it wasn't a genuine transaction that he was borrowing money for? I wouldn't have thought it goes very far towards that.
Well, in our submission, it shows that he is someone who is strategically thinking that if he can engage with the process in terms of seeking to set aside summary judgment, immediate judgment, but without giving any information, so essentially keeping his powder dry for enforcement, because he's provided no information. So it's selective engagement, if you like, with the process of the court. My Lord, I'll turn to the fraudulent misrepresentation and specifically to our arguments on that. As to the authenticity of the trade documents, it's suggested that we have somehow misled the court. I think that's part of Mr. Duckworth's case. The authenticity of the trade, the Lanka documents are discussed or are raised in the documents in bundle D2.
Mm-hmm.
So if I could start at page 9 in D2.
page 9 of D2.
My Lord, yes.
You have to help me. I've got D and D1. Where would I find?
There's a bundle.
The correspondence.
Yes, my Lord, yeah, that's it.
Yeah, okay. Page 9.
My Lord, yes. So there we have SBM writing to Lanka on the 11th of March 2000, so pursuing sensibly its inquiries. And if I could take a look at the last paragraph in that letter.
Yeah.
As we did not receive a response to our email 24th July, we assume that no oil was ever delivered to Lanka. However, we should be grateful if you would please confirm this by return. Also, the enclosed documents A and B were in fact issued by Lanka IOC. So we're asking Lanka there to confirm the position as to both the oil, its delivery, and the documents. So, and I should say we've already asked in July 2018 to the same effect by email. No response is received to that. And then if I could take a look at page 7, the same bundle.
Mm-hmm.
This is a further letter written this year, the 26th of January, to Lanka, again seeking to remake this inquiry, but on Denton's paper, written by Mr. Andrew Chung. Second paragraph, currently no intention to involve you in the proceedings. The purpose of this letter is simply to request your verification of a number of historic transactions which have been presented by Renish to SBM during the course of 2018, and then reference below under 1 and 2 to the 2 award letters, the January and the March award letters. So a request from Denton's. And that produces at page 5 a reply from Mr. Patnaik of Lanka, and this is where he reveals to us, to Denton's, that the award letters, the 3 parcels were delivered, and in paragraph 2, the award letter dated the 23rd of March were issued by Lanka. However, the 3 parcels were not delivered by Renish Petrochem. So yes, it issued an award letter in March, but none of the 3 cargoes were delivered. And my Lord, if one then goes to page 2 in the same bundle, even though there was summary judgment, even though these were potentially subject to litigation privilege, Denton's felt it important to raise this with AMA, with the lawyers in Dubai for the first 4, Renish and Mr. Mehta. And if I could take, and this is the 10th of February, if I could take you to the 3rd paragraph. In addition, we disclosed copies of our recent email correspondence with Lanka IOC PLC. The claim to asserts correspondence covered by litigation privilege, and then insistence that there's no general waiver of litigation privilege. So in terms of misleading the court, that is, in my submission, a stunning suggestion or allegation to make in circumstances where Denton's have fallen over themselves to disclose to the first and second defendants documents that have come to their attention, even after summary judgment, that raise an issue about one of the primary facts on which the judge drew his inference, his overwhelming inference of fraud. That it is staggering that in those circumstances, the first and second defendant feel it appropriate to make an allegation of misconduct against Denton's and counsel. The reasons for the immediate judgment application, I think your Lordship has indicated an awareness that a default judgment would not be conclusive for the purpose of international enforcement, both as a matter of common law enforcement or as a matter of the Indian Civil Procedure Code. We say the Indian Declaration has been a game changer, and it is that which has produced the reappearance of the first and second defendants. Your Lordship will have seen, and it is relevant, the appeal against the immediate judgment, which in our submission was seriously misconceived. It produced a number of very odd, or included a number of very odd submissions. For example, it essentially included an admission of the contractual claim. It said that Mr. Mehta and Renish were unable to pay their debts. That's B, page 114. There was an insistence that the Prime account was operated solely by Prime, and therefore they could have no visibility as to what was done in the Prime account. So they said, well, how could we know what was the flow of funds? And in fact, it's since emerged that in fact all of the relevant instructions were signed by a Renish employee, Mr. Naqvi, and I'll come back to that. Fifthly, there is an attempt at page 1B125 to query the personal guarantee. Again, none of this has been pursued, so it suggested that there was no record of its being signed, it wasn't notarized, the signatories weren't identified. None of those points have been pursued. They are, in my submission, further examples of scraping the barrel. There's a suggestion that there's an allegation that the judge was biased at B127, and all of those arguments in my submission were utterly hopeless. And the fact that they were being deployed at that point reveals a last-ditch, last refuge, if you like, in terms of the quality of the argument. I don't need to take your lordship through the immediate judgment. Your lordship has seen the 7 propositions in that support the contractual claims. Each one of those is plainly correct. And in respect of the fraud, the inference of fraud rests in paragraphs 38 to 44 on 7 primary facts. And again, I don't think I need to take your lordship through those. Each of them was identified by Justice Ali as being indicative of fraud or consistent with fraud. He's an experienced judge in this jurisdiction and in the Dubai courts. He has experience of fraud cases. There was no leading or misleading of the judge. He formed those inferences using his own analysis, if you like, of the evidence that was before him. He had no hesitation in finding conspiracy to defraud, that's paragraph 45, and he saw no real prospect of any successful defence, that's paragraph 46. So this isn't a judgment that's a finding that's, or an immediate judgment that's on the margin, that's on the cusp. It's a judgment in very strong terms, building on the submissions that have been put before him. In terms of the legal principles, I don't know if your lordship has the DIC court practice. I think it's in bundle F, or the section is in bundle F. If I could take you to part 24, which is tab one of the tabs 11.
Yep, tab. Oh, I've got one tab 11.
Well, it's page. I have it as page F160.
Right. Oh, I've got it.
Does your lordship have part 24 immediate judgment?
Yes, yes, it's on page F212. I've got it anyway.
There's been a certain amount of chopping and changing with the, but anyway, if your lordship has internal pagination, page 325 of the DIC court practice.
Yeah.
If I could take you briefly to note 24.1.1.
Yeah.
Your lordship will see that the principles in DIFC procedural law are very substantially those of English law. So, yeah. And GFH capital, which is the decision at first instance of Justice Roger Giles, approved by the Court of Appeal in the IGPL case, restates JSC Bank and Skurikin, and then you'll see in 1 to 10 some fairly familiar principles. In particular, the court must consider that the defence has a realistic, as opposed to a fanciful prospect of success, that it's being essentially presented with conviction. Paragraph 2, a realistic prospect of success is one that carries some degree of conviction and not one that's merely arguable. So again, with which your lordship will be familiar. And then just picking up after paragraph 10 on the following page, about a third of the way down the page, even though the immediate judgment given by Justice Giles in GA Capital was ultimately overturned. That's the famous David Haig case. And the immediate judgment set aside by the Court of Appeal, the decision of Justice Giles has been repeatedly cited as laying down the criteria for immediate judgment. See, for example, Salam Advocates and various other authorities they're cited. And if I could take you, Your Lordship, on to note 24.1.10, internal pagination, page 328. And if I could invite Your Lordship to read that note.
Yep.
In terms of the English cases, I acted in Aurora Developments. It was a complex property fraud over a 3-day period, and the judge now made a summary judgment of fraud based on a hearing of 3 days, and she did it by reference to the observations of Mr. Justice Barling in Zumax, Nigeria, i.e. even a complex matter, if it can be dealt with on the documents, even over a significant amount of days, if that saves a trial of many months, it is a valuable judicial exercise in giving summary or immediate judgment in those circumstances. So there's a line of authority, essentially the Zumax line of authority, that there are important cases where even on fraud allegations, summary judgment can be deployed, where the fraud is evident because of the strength of the inference or the clear documentary evidence. I think, Your Lordship, we looked at, with my learned friend, at Allied Fort. I make the point that Your Lordship essentially picked up on. At paragraph 81 of that judgment, the Court of Appeal made very clear that summary judgment is not precluded, but that caution is required. If we we can. I don't think I need to take Your Lordship to the point, but essentially you can, summary judgment can be granted on...
what paragraph of that I thought?
80, well, let's look at it. It's tab 13, Lord. We may have a décalage. I've got it at page 203.
Paragraph 80.
Paragraph 81, my Lord, is the comment that summary judgment is not precluded. Your Lordship may already have marked that up. So, although summary judgment is not precluded in a case in which the honesty of one or more of the parties is an issue, particular caution should be exercised before depriving a party the opportunity of rebutting allegations of dishonest conduct. And then paragraph 82 is relevant for our purposes. The factual background to the proceedings is not simple and straightforward. The length of the written evidence deployed by the parties, both on the application for and the discharge of the freezing order, and relied on by both sides on the hearing of the summary judgment application, as well as the length of the hearing challenging the freezing order, should immediately have sent a warning signal to the deputy judge. The fact that in the event argument before the deputy judge took up 2 days and his judgment runs to 48 pages comes as no surprise. Paragraph 84. Further, as the deputy judge correctly identified his judgment, at the heart of the defence of the represented defendants is the contention that Allied Fort, in particular Mr. Hartgrove, knew, consented to, and indeed encouraged the umbrella arrangements. Mr. Khan, in his first witness statement, referred in detail to conversations between himself and Mr. Mahmood with Ms. Hartgrove and others as evidence. Oral evidence of that kind, if disputed, is the paradigm type of evidence, the truth of which cannot, save in exceptional circumstances, be determined on a summary judgment application. Well, we would say, in distinction to the surface of the facts of that case, that the issues in our case were summarized in an 11-page judgment. There was no issue as to what was said in any oral discussions. The contractual claims were clear on the documents, and what Mr. Mehta and Renish had done was substantially, for example, in terms of absconding, was substantially undisputed, and the flows of funds can be amply evidenced in terms of the bank statements. So we are, in our submission, a mile away from the highly complex facts and the particular circumstances that pertained in Allied Fort before the deputy judge. GFH and Hague is in the bundle. Perhaps worth looking at. I've got it at page 247 in this bundle.
Yeah, I've got it.
And if I could take you briefly to paragraph 12.
Yeah.
And if I could invite your lordship to read paragraphs 12 and 13.
Mm-hmm.
And as we've seen from the note in the DRC court's practice, that the statement of principles by Justice Giles, in this case, have been widely cited in a number of subsequent DRC cases, and which is surprising because in our submission it's a rather orthodox statement of the need for caution, but the reality that summary judgment or immediate judgment can be given on allegations of fraud and dishonesty. Whilst we're still dealing with the authorities, a question, I think my learned friend sought to undermine the submission that your lordship needed to find that there was good reason for Renish and Mr. Mehta not attending the hearing. We have that in Professor Zuckerman's commentary on the civil procedure, which I think is towards the end of this bundle.
Zuckerman, chapter 9.
Yes. And if I could take your lordship to paragraph 957, subsequent judgment may be awarded against a respondent who fails to appear at the hearing of the application. However, the respondent may apply for the summary judgment to be set aside, practice direction 24, para 8.1. In such circumstances, CPR 2311 applies, and the court would consider as relevant the approach taken to applications under CPR 39.35, so that it would grant the application only if the respondent acted promptly when it found out about the summary judgment and had good reason for not attending and has a reasonable prospect of success at trial. And there's a footnote there to footnote 138. That footnote is to various cases, including the tube-like case, which is the first case in this authorities bundle.
Sorry, can you just give me a second? What paragraph were you reading from before?
Sorry, I was in Zuckerman and I was looking at paragraph 957, my lord, at the bottom of what.
Yeah. Yes.
And my lord, those paragraphs are the CPR analogues of the RDC provisions, to which we took you in our skeleton argument in part 24 and part 35. So essentially, the provisions for the absence of a party at trial apply equally in respect of an application to set aside a summary trial, if I could put it in those terms. And then the tube-like, which is the decision that Professor Zuckerman relies on, among others, that is at the very front of this authorities bundle.
The authorities start with RV Kensington Income Tax Commissioners. What case is tube-like? Okay, I've got it. It's F100.
I'm grateful. If your lordship could turn up that case, that report,
yeah.
And then if I could take your lordship to paragraph 22 within the judgment.
Yeah.
And just if I could invite your lordship to read paragraph 22, it essentially reflects what Professor Zuckerman says in his textbook.
And Rule 39.35 that's referred to there as, remind me without turning it up.
Well, that's the one which deals with when you're seeking to set aside a judgment formed at a trial at which you weren't present. You need to show as a precondition of your application that you acted promptly and you had good reason for not attending.
Yep.
So essentially, the rules that apply in respect of a trial and non-attendance at trial are imported into the provisions dealing with an application to set aside a summary judgment. So standing back, my lord, essentially there are two preconditions. So the respondents have to show that they acted promptly and that they had good reason for not attending. Now, I think the highest that my learned friend put it this morning was that they had a tenable explanation for not attending. And in our submission, that is falls a long way short of a good reason for not attending. Now, if you've torn the telephones out of the wall and cut all communications, that in itself, in our submission, is not a good reason for your non-attendance. It's a willful decision to avoid being informed of the legal action, which is almost inevitable when you have failed to pay the sums that these entities failed to pay. And indeed, we say, given that that it was sent to his the MD email, given that it was served on his Dubai residential property, we find it extraordinary, the suggestion that he had good reason for not attending. And given the circumstances of his reappearance, and we say the likely strategic calculation in his reattendance in our submission, he did not have a good reason for not attending. So we say he doesn't even get to go, if you like, in terms of the preconditions under, as described in Professor Zuckerman's text. Then there's the issue of the court having to find essentially that he has a real prospect of defending the fraud allegations. And you will have seen, my lord, that we say the inference is still strong, and indeed stronger since the summary judgment was granted. Then your lordship has to exercise the discretion under RDC 24.23. So the court may make such order as it thinks just. So there are, by implication, even if all of the conditions are satisfied, the court may decide that there is no justice, and I'll come on to prejudice to SBM. There's no justice in setting aside the immediate judgment. And lastly, while we're dealing with law, if the court does set aside, it can attach conditions. And your lordship has in the authorities bundle the case of Mohan Smith, which I have at page 16 as the second authority in the bundle.
I got it as a seventh.
Okay.
F115.
My lord, yes. And so if I could pick up in the holding in the head note.
Mm-hmm.
Held, allowing the appeal, there was a material and important distinction between application for an adjournment of a trial and application pursuant to CPR 39.3.3 to set aside judgment entered in default because of non-attendance. Then picking up at paragraph 30 of the judgment.
Paragraph 30.
Paragraph 30, my lord, which is at internal pagination 2930.
Yeah.
Except that the court should not overlook the position of opposing parties' claims in this case if the court is satisfied that the condition in Rule 39.3.5 are met and its right to exercise its discretion to grant the application, it will often be appropriate to allow the application on condition the applicant pays the other side's costs and pays a sum on account of those costs within a short period. So the proposition that where a court has a discretion to set aside an order, the inherent in that discretion is the fact that it may set it aside on terms or on conditions. I'm slightly taking things slightly out of order, but there is a suggestion that hasn't been pushed by my learned friend in his oral submissions, that there is a duty of full and frank disclosure where a party is absent. That he relies on that in the State Bank of India and Malia case. It may be worth looking at that quickly just to knock that point out. That's at page. I have it at page 35 in Bundle F. Yeah,
you would. I have it at 163.
Okay. So if I could go straight to page, I have paragraph 103, my lord. Sorry, I appreciate that's quite a long way down the judgment.
Right, paragraph what?
Paragraph 103.
It'll take me a minute.
F188, my lord.
Yep, I have it. It's a simple question of it coming on screen. Yeah. Okay, I've got it.
So dealing here with a worldwide freezing order, so this isn't a question about, this isn't a case about absence, this is a case about an ex parte application. Paragraph 103, in addition to his argument that the registration order should be set aside, Dr. Manley advances 3 grounds on which he says the justify the UFO being set aside. And then if I could turn on to paragraph 184, sorry again for scrolling.
184.
184, my lord.
Mm-hmm.
And you'll see this comes under heading material non-disclosure in the same analysis. Paragraph 184, the requirement of full and frank disclosure has been described as a heavy duty of candour and care. It is the quid pro quo for an applicant inviting the court to proceed in the absence of another party. So again, this isn't a question of absence. This case is dealing squarely with the circumstances of an ex parte application for a worldwide freezing order. So the suggestion that if a party can absent itself, that the lawyers for the other side are then under a duty of full and frank disclosure. In other words, to put the evidence against their own client's case, to put the arguments against their own client's case, makes no sense at all, and is not reflected by the very authority on which the first and second respondents rely. To conclude on contractual liability, if one looks at the proposed defence, we say that would be entirely demurrable. It's perhaps worth doing that. That's in bundle A.
What number?
Page 49, if I could start page 49.
Yep.
So this is the proposed defence. This is if the summary judgment the immediate judgment was set aside, this would then become the defence of the first and second defendants. So if one starts at paragraph 5, you see there the admission paragraphs 5 to 7 of the particular claim are admitted. So those are the circumstances of the facility agreement and the personal guarantee. So that's an admission of those. And
sorry,
then,
I may have a different document.
sorry, I'm at page A51. A51.
But what you're looking at paragraph 5, you say?
Yes, I am. At the top of A51.
Forget about the page numbers for a moment. What does it start with? Paragraph 5. What does it say?
Say that SBM conducted its own due diligence.
Right. Okay.
Does your lordship have that?
No, just give me a sec. Page 51, A51.
My lord, yes.
Yep.
So, and at the end of that paragraph, paragraphs 7 to 11 are admitted. Those are the paragraphs which set out the facility agreement and the personal guarantee.
Yep.
And then if I could take paragraph 8 down the page. Subject to proof of relevant books and records, subject to the point of paragraph, it is acknowledged that the full repayment of the bank facility has not occurred for reasons beyond these defendants' control. The alleged breaches of contract are denied. So an admission that the monies haven't been paid because of reasons outside our control. And we would say it's a fairly trite point of law that actually that is not a defence to a breach of contract if you can't, if you're unable to pay. And then scrolling down to paragraph 12 in the same document. It is acknowledged that the bank has not been repaid certain sums advanced to it by Prime for reasons beyond Renish or Mr. Mehta's control.
Yeah.
And then page 57. Bottom of that page, paragraph 35. Although these events put him in breach of the SBM facility and his personal guarantee to the bank, this was not intentional on his part and certainly not fraudulent. So again, implicit in that is an admission of breach of contract.
Yeah.
And in terms of the payments made, your lordship has Annex A, has the flow of funds, so your lordship can see the sums that have been paid and when they've been paid by reference to the relevant documents. Annex A is at E74. I don't think we need to go back to it. And one sees the relevant documents that have been exhibited. So, for example, if we have the NBK bank statements. So within bundle A, if one goes to page 253,
yeah.
So and one sees there the NBK bank statement, and halfway down the page there is the £13 million paid into the Prime account.
Mr. Reid, I don't understand the defence to say that there was any defence to the contractual claims apart from points raised in argument.
My lord, yes, there's been a certain amount of floating of points about the absence of licence, etc. I think I've discussed that. It's not pleaded in the draft defence. As a matter of English law, it makes no sense. Your lordship will be aware of the Supreme Court decision in Patel and Mirza that even if there's unlicensed activity, that doesn't automatically result in illegality. And even if it did, there would be restitution, full restitutionary claim. So that doesn't provide any defence. Even if it had been pleaded, if it were pleaded, the pleaded response would be one of a restitutionary claim. So that provides no defence, we say, even if it were either pleaded or B, had any substance in terms of the international provision of finance by a Mauritian bank from Mauritius.
Do you have, is Patel and Mirza in the bundle?
My lord, it isn't. We can have it put in the bundle if that would assist.
I wouldn't worry. I can look it up if I need to.
My lord, yes. The relevant paragraphs are paragraph 116, which is Lord Toulson saying there's no automatic illegality pursuant even if there's no licence. Paragraphs 202 to 203, paragraphs 210 to 211.
Yeah.
So, my lord, we say that the finding of fraud, the contractual claim is secure, that the claim of fraud is secure, and we say the impropriety, the allegations of impropriety against SBM are extraordinary. It was perfectly proper to plead fraud. If you're going to take trade finance and then disappear or abscond, there is likely to be an inference that you have acted fraudulently. Lanka, as we have said, declined to confirm that there had been a contract, that it had received the oil. The circumstances of the absconding were extraordinarily suspicious, not least in circumstances where we had been talking by the WhatsApp and by email about repayment. And it was only after that WhatsApp giving the assurance that Mr. Mehta then disappeared. And of course, we recognise Prime's case, which was that the Prime documentation had been forged. So the evidence suggested that the prime contracts had been forged. It was a very reasonable inference in our submission that the Lanka contracts had similarly been forged. But in any event, that is not at the heart of our fraud claim. In the skeleton, we made clear that it appeared that the Lanka documents may have been forged. At the heart of the fraud claim is the fact that they had no genuine intention to repay. The intention was to abscond without paying. That intention is clear from the flow of funds. They weren't being used to fund trade. If you haven't used the funds to trade, there are not going to be the proceeds of sale, which you're then going to repay the finance. Once you've simply taken the money, there is never going to be the money from a purchaser with which to repay the finance. You know the die is cast essentially in terms of the non-repayment. As for the misleading of the court, we find an extraordinary allegation. The judge made his own assessment in drawing his inference. You have seen, Lord, the disclosure in respect of the Lanka correspondence. So we kept writing to Lanka. When Lanka did eventually reply, we made voluntary disclosure of that, knowing that it would be grist to the mill of the first and second respondents. We did that because it was we considered it our professional responsibility to do that. And if I say so myself, in my submission, the professional conduct of Denton's in doing so was exemplary and far from being subject to the criticism that's been levelled on behalf of the first and second respondents. We say the alleged circumstances of the absconding are utterly implausible. We say when you look at the distribution of proceeds on the flow of funds, when you look at the other circumstances, you look at the assertion of Mr. Sargent that the prime contracts were forged. When you look at the fact that the prime account was controlled by a Rhenish employee, Mr. Nakvi, and I will just touch on that in a moment. All of those circumstances lead to a strong finding, a strong inference of fraud. I don't think I need to discuss further the flight, the cessation of communication, the closure of the offices, all of which we say are discreditable, all of which are strong indicators that it was never the intention to repay this finance.
I think, Mr. Reid, your summarising points I already have, I think.
Yes, that's why I'm slightly galloping through them, and I apologise for doing that.
Help me with this. What if I decided that there was no defence to the contractual claims, but that I thought there was an arguable defence or realistic possibility of defence on the fraud claim? What do you say I should do then?
Well, in those circumstances, my lord, the judgment as such is the order. There is nothing in those circumstances that is wrong with the order. The order stands. There is no setting aside of the judgment in the sum of the judgment. If your lordship then gave, if and insofar as it is said by Mr. Mehta that he needed the protection of a judgment or some public statement, your lordship's judgment in arriving at that finding would give him the account that he says he would say he needed, there is certainly it would be absurd in my submission to suggest that your lordship needs to set aside a default judgment and then remake it. The order on its face is correct on those assumptions, and it would just be a matter of your lordship explaining your reasoning as to why in your lordship's submission there was it was possible for Mr. Mehta and Rhenish to produce an argument with conviction on fraud, that they had a reasonable, realistic prospect of success on a defence to the fraud allegations. But as I've said, in our submission, given all of the circumstances, and I do just want to quickly pick the NACV point, because I don't think I have made that. And if I could take, so your lordship will have seen, yes, the grounds of appeal, I do just want to show you that quickly. Bundle B, Lord. If I could take you to page 149.
Mm, 149. Yeah. Yeah.
Paragraph 15.3, the letter raised caution with SPM, who started demanding payment of dues on an urgent basis, on the basis of rumours. It's pertinent to note that Renish itself is owed substantial sums of money from various parties in the UAE. However, owing to adverse market conditions, none of the said debtors were able to pay off the debts owed to Renish. Consequently, Renish was put in an adverse position where Renish was unable to pay loans to lenders within such short periods. Owing to the said circumstances, Mr. Mehta was unable to finance any legal course for recovery of monies owed to Renish, and Mr. Mehta assumed that adverse legal action would be taken against him. So we pick up on the assumption that he made that he would be being pursued, and this really goes to our willful blindness point. That here is a defendant, here is someone who has absconded, not paid back. The monies have been redistributed amongst between Prime, Renish, and various related parties, and he assumes that legal action will be taken against him, and yet he says it is reasonable for him not to have been absent at the trial. The only reason he's absent at the trial is because he deliberately ensured that he did not find out about the legal action that he assumed was taking place against him. And we say that is thoroughly discreditable, and he fails to satisfy the precondition for a setting aside of the immediate judgment, strengthening the absence of fraud. The other point which I've, just a small point of detail I want to raise is in respect of Mr. Naqvi. So it is said we have seen that Renish and Mr. Mehta deny any knowledge in the most emphatic terms as to the operation of the Prime account. But the reality is that that account was operated substantially by Mr. Naqvi, and we get that in Bundle A. And if I could take you to page 296.
Yep.
And this is the Indian passport or identity card of Mr. Syed Adil Naqvi, and you see the signature there. And if you see particularly the way he writes Adil in a very distinctive way, with the cross on the A and the L going down below the line, and then basically above that we have a lot of, if I could take you to page 103 in the same bundle.
103.
So this is a paragraph in SBM's response to the set-aside application.
Yeah.
Now, in the set-aside application, it's been said by Renish, we knew nothing about the Prime account, but in fact, and here at the bottom of this page, 5.14 little a, halfway through the paragraph, Mr. Syed Adil Naqvi was an authorized co-signatory of the Prime account along with Mr. Farhang. Mr. Naqvi was at all material times employed directly by Renish, as can be seen by the UAE visa, which states his professional accountant. It appears Mr. Naqvi on each and every payment transfer to request to MBK made from the 4th of March to the 13th of May 2018. So Renish is not only aware of the transaction taking place, but was itself involved in authorizing them. And we can just...
that was paragraph, what paragraph was that?
Sorry, that was paragraph 514 little a, page 103.
And can you, I failed to make a note of it, the page number of Mr. Naqvi's passport is what?
A296.
Thank you.
And then if we could just quickly look at A131.
Yeah.
So this is an example of a check written on the NBK, the National Bank of Kuwait account, and you'll see the signature there of Mr. Naqvi, the Adil, the very distinctive Adil. And then it turns on, and there are numerous examples of checks signed by him. And then if one could turn off to 137.
Yeah.
137, we have a funds transfer form, again, written on the NBK account. Bottom left-hand corner, we see again Mr. Naqvi's signature, Adil.
Yeah.
And Your Lordship will remember from my learned friend Skeleton that Renish and Mr. Mehta are coy in respect to Mr. Naqvi. They say Mr. Naqvi could be a prime employee, but there's no denial that he was in fact a Renish employee. And we know that he was a Renish employee because if we go to the same bundle to page 298,
yeah.
And there we have the residence permit, the Iqama of Mr. Naqvi. To reside in the UAE as a non-citizen of the UAE, you have to be sponsored by an employer. And on the right-hand side, you see sponsor, about the fifth item down, and the sponsor is Renish Petrochem FZE. So this is Renish, who are said on his Iqama, his residence permit, to be his sponsor, and it is therefore a very strong inference that they are his employer, because it's the employer that sponsors, and indeed he's an Indian national.
Yeah.
So, we say all of these circumstances, the flows of funds, the flimsy attempts to explain the absconding, the fact the control of the prime account was partly in the hands of a Renish employee. We say the inference of fraud on the documents without the necessity of any cross-examination is overwhelming. The judge was right in his inference, and therefore the summary judgment, the immediate judgment, just stand on both bases. And we don't withdraw from that submission. We make it strongly, and we say even before your Lordship gets to a discretion in terms of saying that the finding, the necessary pre-finding that they had a good reason for not attending in circumstances where it was they who had torn the telephone out of the wall, it was they who had assumed that they would be pursued by legal action. But
I think I had that point.
I'm going around. I'm going around in circles. I apologise. It is just worth finally on the issue of justice considering the prejudice to SPN. Although there is an invitation in my learned friend Skeleton that the court should hold a judicial inquiry that somehow having all of the protagonists together in the same bathtub, cross-examining each other on their own accounts, that somehow that's a better way of getting to the truth. Of course, we understand that, but one has to consider this from the perspective of the prime. We already have, SPN, we already have a 7-day trial of the allegations against Prime. Prime has put in a substantial defense in a very lengthy witness statement. They put in a reconstruction of the ledger of trading between Prime and Renish. They have got permission for experts. That is a very substantial trial in its own right. And we accept that there's an arguable defense in the case of Prime as to whether it was participating in the fraud that was perpetrated by Renish as the borrower of the trade finance. That Renish and Mr. Mehta in our submission do not have that defense. The defense they've sought to raise is implausible on the documents. They have no defense from contractual claims. It would be very unjust in our submission to put SBM to the cost of a trial substantially longer than the already existing 7-day trial, cost that would potentially be unrecoverable. And
so this is on what hypothesis? This is on the hypothesis that I gave. I set aside the judgment altogether.
This is about any setting aside, Lord. If
I upheld the judgment, but on the basis that the liability was contractual and there might be arguments about fraud, then why would that be unjust?
Well, no, my lord. If your lordship were minded to set aside the immediate judgment, if your lordship's not minded to set aside the immediate judgment, then the problem of a lengthy trial unless
it arises if your clients nonetheless wanted to proceed with a claim for fraud against the first two defendants.
Well, my lord, yes. So that would be you're right, my lord. That is it's also an argument on that. I accept the weight of your point. It's a strong argument too in respect of a finding that there is a real prospects of defending the fraud allegations. If those allegations are resurrected and allowed to be pursued at a trial in October, there will need to be a significant extension of time of the October trial, which is already listed for seven days.
Sure, it's my fault, I'm sure. In the action against the third defendant, Prime, don't you have to prove there was a fraud by the first two defendants?
Well, my lord, we do. If the summary judgment on the basis of fraud, then we would have.
Immediate judgment doesn't help you on that point against Prime, does it?
Well, to the extent that there would be an immediate judgment with findings that there was a fraud, and your lordship will have seen there's reference to a finding that there was a fraud by Renish and Mr. Mehta. So to that extent, how would that be binding on Prime?
It wouldn't be binding on Prime, Lord, and we would, to the extent that we've made a summary case for fraud by Renish and Mr. Mehta, we would have to lay out the very documents that have been laid out before your lordship, and I would have to spend 2 to 3 hours explaining the circumstances in which the summary judgment, the summary finding of fraud was made. I accept your lordship's right. That finding would need to be made against Prime, but that is it would be a completely different order of complication and additional cost if Renish and Mr. Mehta entered the fray with their essentially they're seeking to explore the inconsistencies in their defences and the defences of Prime. But my lord, we don't need to explore those in terms of the judgment, the immediate judgment that's already been made against Renish and Mr. Mehta. So there would inevitably be a substantial ramping up of the costs of any judicial inquiry. It would add nothing to our understanding on the documents of the fraud that we say has been committed by Renish and Mr. Mehta. And it would further have a very significant impact in terms of the delay in enforcement. The SBM has lost these funds in 2018. Mr. Mehta purports to be a wealthy individual. He has assets, we believe, in India, and we need to be able to enforce against Mr. Mehta and his assets in India. And clearly, if the summary judgment, the immediate judgment, were set aside, and we were then dealing with a lengthy trial and then a period before judgment, which could be many months, that would be a significant delay and a very real prejudice to SBM in terms of recovering its monies. So we make that point too in terms of prejudice. If your lordship is in the business of exercising discretion, if your lordship finds that there's good reason for the absence of Renish and Mr. Mehta. And I should say that in terms of enforcement, an order for immediate judgment being upheld, but on some terms that payment is on the order was delayed. That makes no sense to us. There's no precedent for an order for delayed enforcement. We entirely agree with your lordship's point this morning that if monies are owed, then an order should be entered as to how various creditors and how their claims relate. Well, that's a matter of insolvency law. And it's not a matter that's raised in these proceedings for this court at this stage. So for all of those reasons, my lord, we say the application to set aside should be dismissed, and we say it should be dismissed with costs. And we say we're content that those costs should be assessed by way of a detailed assessment. But we do, insofar as the immediate judgment was the costs were ordered on an indemnity basis, we would say the same basis should apply here, because we are a long way from the norm, and we rely on all the circumstances and all the primary facts on which we base our inference of fraud.
Yes, thank you very much. Mr. Duckworth,
yes.
two points really. Well, first, were there any factors that were raised which you haven't had a chance to deal with? And secondly, do you want to fill me in on the couple of points you were looking at?
Yes, of course. Before the short adjournment, your lordship asked me a couple of questions about, first of all, Mr. Sadr's evidence of involvement in trading in Iran. I delegated that question to my instructing solicitors, who reminded me that paragraphs 55 to 95 of his witness statement tell the story essentially of the company's involvement in Iran oil deals. He makes it clear that this is the bulk of the company's trade, and so to the extent that trading with Iran is or was prohibited at the material time, it may be that the point of illegality does still arise in the case. I hear what Mr. Reid says about the President Trump's withdrawal from the extreme sanction position, but we aren't sure without further investigation whether that completely absolves the bank from the problem. And I'm sorry that I can't give Your Lordship chapter and verse on this at the very moment, but that is the extent of our researches at the moment. With regard to the second question, yes, with regard to the second question, which I think was there any authority for a bank's duty in terms of contributory negligence? I've not been able to carry that point any further, my Lord, and so I'm going to put that to one side, if I may. There is an issue raised in Prime's defence about the failure of the bank to carry out proper due diligence, and it could be that in the last analysis that will play some part in the apportionment of liability in this case, but my understanding or instructions on that point are not sufficiently clear at the moment to be able to say either way. The third question I think that arose was linked to the first, namely the relevance of SBM's banking license or not. And I hear what Mr. Reid said about SBM being a non-resident company, in fact based in Mauritius. It may be in those circumstances that it doesn't have to have a banking license to offer services to free zone based companies. We wouldn't like to be dogmatic about that, but as I say, these are matters that would be investigated in the ordinary course of preparing our next steps. I don't think I can take it any further than that. Dealing with the, if I may, with the more general points made by my learned friend, may I start with this point, that my lay client, Mr. Mehta, is a Gujarati national whose first language is not English. To the extent that Your Lordship's findings or decision may turn on small points of interpretation of how he cast his evidence in statement or otherwise. For example, whether he it was a chance internet search or a tip-off, and whether there's any real distinction between that in his mind, it is not something on which we would like Your Lordship to place such weight as Mr. Reid suggests. Allowance has to be made for difficulties, for frankly losses in translation, and sometimes this can be can have severe complications. The next point I would like to make is that we still don't understand what the bank's case is on fraud. It began as an exercise in demonstrating that every piece of paper from the very beginning was forged and was brought into being for the sole purpose of deluding the bank into parting with vast sums of money with which Mr. Mehta would then flee the jurisdiction. Lord, we simply don't understand this because there's been a significant change in the ground works here. The discovery that the Lanka contracts were indeed genuine was made by Denton's in January of this year. But, my Lord, it was known to SBM well before that. It was fully known to them, in fact, because, for example, if you look at some of the exchanges of correspondence between SBM and Lanka, you find that they were, in fact, corresponding with Lanka. Let me refer Your Lordship, for example, to D1, page 784, D1 784. this is an email dated 24 April 2018. I think I may have referred to it in opening, but as you'll see, it's written to a colleague within the bank, Mr. Malek, who was, I think, the manager in charge of this loan facility. And in it, Mr. G. Mungol says, I have just done a callback through Lanka IOC PLC switchboard. I've spoken to Anuj Jain, Senior Vice President Finance of Lanka IOC, and the latter has executed the assignment of receivables. Of note, and so on. He goes on. And then, if that were not a sufficient indicator, page D1848 takes it a step further. Again, Mr. G. Mungol tells his colleague, we have spoken to the Senior Vice President of Finance of Lanka, same gentleman, and he is confident to effect payments of the last two deals detailed below on time. There's no question of this being fraudulent or fictitious trade contracts. These were all going through to plan. My Lord, Mr. Reed's analysis and his client's analysis turns very heavily on the sequence of 6 deals, and indeed he was, his clients wanted at one stage to limit it to 4 deals, but there were 6 deals. However, these have to be set in a much wider context of the overall relationship between the bank and its client. If I show your lordship 2 pages before this, page 846, I think again I showed you this before, but it's dated the 4th of June 2018, and it shows that it wasn't simply the prime contracts that SBM was dealing with. It had numerous other loan arrangements with this borrower, Rhenish Petrochem, including a loan contract in favour of ADNOC. My lord, that's, as your lordship knows, is one of the largest refineries in the Middle East. Import loan to Shell, import loan to Aria, another 15 million loan in favour of ADNOC, another 3 million loan in favour of ADNOC. Before we get to the prime energy deals, and then other companies at the foot of this table, Lord, the total facilities were 83 million. This is the client that the bank was dealing with. As Mr. Reed rightly observes, it was a substantial enterprise. It was a company with 50 million dirhams turnover and 250 million worth of assets. Is it to be supposed that a bank of this stature, an oil company of this stature, would turn to grubby fraud for a very small, relatively speaking, relatively small amount of money, and then Mr. Mehta do a quick runner to India and close everything down? It does raise many, many questions which can only be investigated on further evidence. Next, Mr. Reed said that there was ample evidence that the defendants came to learn of these proceedings and deliberately took no part in them. But we don't accept that for a moment. Mr. Cheong, who swore an affidavit earlier in these proceedings, said that he couldn't prove service. If your lordship looks at page D592, you will see what he says. Does your lordship have that page?
Not quite. About to get it. .592.
592. And it's a paragraph, well, it's under the heading Service of the Worldwide Freezing Order on the Defendants. And if you look down at paragraph 33, he deals with the emails and the bounce backs and so on. And he says that one of the emails didn't bounce back. That's the one that Mr. Reed relies on. But he frankly admits in the last sentence, that said, this is only an inference, and I have no way of confirming that actual delivery took place to his email inbox. My Lord, we don't know why the bank took no steps to ensure that Mr. Mehta was properly served in India. Had they done so, these questions we wouldn't be arguing about them now. But the possibility exists, and I would invite your Lordship to keep it in the back of your mind, that the bank itself took a strategic or tactical decision not to serve him. That would have presented a number of advantages. If they could prove substituted service through emails and so on, then they could get their judgment and start enforcing.
Well, I think Mr. Duckworth, this is raising a fresh matter, which, if you wanted to raise it, it could have been raised earlier on in your submissions, and Mr. Reid could have dealt with it. I'm not going to entertain that submission at this stage.
Very well. I rest with my point about service, that it's not been, on the bank's own admission, it's not been proved. My Lord, a lot of this case seems to turn on inferences and probabilities, and I have already made the point in as many words, but I put the point more roundly. Does a company of Rhenish's standing, which is not only from its accounts demonstrates a strong base, but also, my Lord, from the annex to my skeleton argument, in which I showed you, I don't know if you had a chance to see it, a press report dating from March or April 2018 from a rating agency in London, were speaking highly of the company and its prospects. Is it to be thought that Mr. Mehta would sacrifice all that for a few cheap dollars, which is effectively is the case put against him? Lord, turning to the authorities, in the Allied Fort case, it is true that a fair reading of that decision is that the court must be very cautious where dishonesty is alleged and not resolve issues of fact. I also invite you to bear in mind the dictum of Lord Steyne, which is referred to in that case, and which we referred to in our application to set aside. I don't know if your Lordship would like me to turn to it, but essentially what it said is,
I can find it.
Yes, it was in a sense a statement of common sense that that cases which look very overwhelmingly provable at the interlocutory stage may somehow disintegrate at trial, and a different result comes out once the witnesses go into the witness box. With regards to the Hay case, well, the fact of the matter is that although the first instance judge set out clear principles which were followed, his actual decision was reversed on appeal for the very reason that we advocate in this case, namely that there was an issue of dishonesty, and it would be wrong to deprive the defendants of their opportunity to defend that. So his decision was reversed, and it followed on to a trial. Of course, other things happened. I believe at the actual trial, the defendant didn't turn up anyway. So that Mr. Reid is laughing, and perhaps he's right to do so. But the point about that decision is that the finding of dishonesty can move, as the court said, the court to permit proceedings to go to trial, notwithstanding the apparent strength of the claim. So strength of the claim is one thing. It's something that Mr. Reid has very heavily relied on. But despite the strength of the claim, the court may still permit the case to go to trial if there is an allegation of dishonesty. Lord, in this case, there remain many issues of fact, not least the question of the manner and way in which Mr. Mehta left the country in July 2018, or rather stayed out of the country once he was out. And my learned friend has used colourful expressions like tearing telephones out of the wall and so forth. That's all very well, but sometimes fact is stranger than fiction, and we do not know it. What we do know is that for sure the bank commissar had presented a cheque which was dishonoured, and there is still a tangible risk, whatever the state of the law. I'm instructed that where there is a debt of any significant size, to pass a cheque that is dishonoured, it does put you at risk of criminal proceedings, or at any rate of a police investigation. I don't know to what extent your lordship can use your own knowledge, and to a certain extent we're all using our own experience or limited knowledge here. But those are my instructions, and my instructions come from the firm of Ashish Mehta, which has been practicing in this jurisdiction for many years, and indeed who has clients that it has to defend in the criminal courts for dishonouring checks, very often for much smaller amounts than we're talking about here.
Yeah.
I'll move on quickly with regard to the duty of full and frank disclosure. My learned friend took issue with this and said that that only really applies where there is an injunction is being applied for, as I understand was the way he put it. Lord, in our submission, it's wider than that. It's a very broad duty, and it arises wherever a party proceeds in the absence of another party. And in support of that submission, I would like just to touch on two authorities that have been put in the bundle. One is the Kensington Income Tax Commissioner's case, which is at page F1.
Yep.
And some way into the judgment, unfortunately it's not divided into numbered paragraphs, there is a judgment by Lord Justice Warrington perhaps I should explain.
Any idea what page?
Yes, it's page 509 of the report, and I think it's F24 of your lordship's bundle. Lord, what had happened here was that the Baroness Polignac, or Princess Polignac, challenged an assessment made by the revenue on the grounds that she was resident in or had a property in London that was liable to tax. Her case was that it didn't belong to her, and in order to advance that case against the revenue, she took out what's called a rule nisi, which I think we would call a notice to show cause, why the the proceedings should not be stopped by a writ of prohibition. She made that application ex parte, and it succeeded at first instance. But on appeal, the order was discharged for this reason, that it was found that in truth she was the owner of the London property and simply hadn't disclosed the position to the court. And in his statement of principle at page F24, internal 509, Lord Justice Warrington says that it is perfectly well settled that a person who makes an ex parte application to the court, that is to say, in the absence of the person who will be affected by that which the court is asked to do, that's a statement of very general principle, is under an obligation to the court to make the fullest possible disclosure of all material facts within his knowledge. And if he does not make that fullest possible disclosure, then he cannot obtain any advantage from the proceedings, and he will be deprived of any advantage that he may already have obtained by means of the order which was thus wrongly obtained by him. Well, that's why we say the claimant acted badly. Of course, I don't criticize the lawyers in the case, they were acting on instructions, but we say SBM knew full well that the Lanka contracts were not forged. It had spoken to Lanka's officers, his financial, the Vice President of Finance, and Lanka itself had confirmed that the first three contracts had performed perfectly well, and now it was waiting for further deliveries. So the bank simply had no grounds to assert, as it did at the immediate judgment hearing that those contracts were forged. One cannot assess the extent to which that would have affected Justice Al-Madani's mind, but it must have had a powerful effect for him to react as favourably, we say, to the bank as he did. Now that the truth is known, a different approach needs to be adopted. The claimant needs to redefine its case and amend its pleadings, but has chosen not to do so. But still, apparently, we're having to do guesswork as to what's in the bank's mind. The other authority, my lord, which is relevant on this point is the L&Y regional government, item 4 in your list of authorities, page F76.
Yep.
Well, this is a decision of Mr. Justice Hamblin in the Commercial Court, and it involved a territory, a foreign territory, over which there was some doubt whether it was a separate state or not. If it was a state, then Section 12 of the State Immunity Act meant that it couldn't be served in the ordinary way. The claimant would have to seek special permission to serve it. The claimant, who was represented by Freshfields, took the risk that it wasn't a truly constituted state and didn't go through the official channels, but simply commenced the proceedings to turn it into an arbitration case. And it was held on the reference to the judge that there was no excuse for the failure of Freshfields on behalf of the claimant to disclose the provisions of Section 12 of the State Immunity Act. Lord, it's a long judgment, and I don't want to go any further into it than I need to, but in relation to the duty of disclosure, may I ask your lordship to look at the last portion of the judgment at paragraph 73 onwards. Here the judge asked himself the question whether the two orders obtained in November and December should be set aside for failure to make full and frank disclosure, and he stressed that it was vitally important to make full and frank disclosure in circumstances where, here quoting the Siparex judgment by Mr. Justice Bingham as he then was, that the applicant must disclose all facts which reasonably could be taken into account by the judge in deciding whether to grant the application. And Lord, that is in a situation where ex parte relief of an interlocutory nature has been applied for, in that case to refer a case for arbitration, without disclosing to the court the weaknesses in the claimant's case. That is a course that should have been followed by the bank at the 9th of September hearing, but was not. May I turn to the question of whether Mr. Nakvi is, as has been suggested, an employee of Renish? There isn't any evidence of this. No contract of employment has been produced, nor has the witness been proved to tell the court whether he is an employee or not. What we have at page A298 is not a statement that Renish was his employer, but that it was his sponsor, which is a very different matter. My lord, my client frankly admits, Mr. Mehta frankly says that he is in the practice of sponsoring employees to other firms through Renish's company. So it really is a flimsy ground on which to base an entire case that Renish was a co-signatory of the NBK account, that somebody who is described on the visa as being sponsored by Renish is in fact, and was at all material times, an employee of Renish. Once again, that's one of those disputed areas of fact that simply cannot be resolved at a hearing like this. It would have to be looked into quite fully. But we make the point that it would be extraordinary for a bank of any self-respecting bank, let alone the National Bank of Kuwait, to delegate the powers of signing checks and bank transfers from Company A to an employee of Company B who on the face of it is nothing to do with Company A. That's just simply unthinkable. Lord, finally, what should your lordship do in the circumstances? We say that the failure to disclose to the court infects the whole of the judgment, and that it should accordingly all be set aside. But if your lordship is against us on that, then we say that the defendants should have the opportunity to go to trial on fraud, and that you should preserve the ring so that the claimant doesn't get any unfair advantage out of the finding, out of the completed judgment, while it is pursuing remedies of fraud against the first or second defendant. If the claimant elects to abandon the fraud claim, then we would have no objection, assuming that your lordship were to find that that judgment should stand in relation to the money part of it. We could have no real objection to them enforcing at that point. But that is not the position. If the bank enforces now, the probability is that Mr. Mehta and Renish will not be able to defend the fraud claim that's been so far established against them. Their name will be forever blackened in the oil industry, and it's unlikely Mr. Mehta will ever trade again. So I'm asking your lordship to give very serious consideration before allowing that kind of situation to develop. I think those are all the points I had in mind to make, my lord.
Yes, thank you very much.
Thank you.
Yes, well, thank you both very much for your helpful submissions.
My lord, could I just make one point? Your lordship asked about Mr. Sarge's evidence on sanctions, and I think it was suggested you needed to read most of his witness statement. In fact, paragraphs 43 and 44 of Mr. Sarge's statement deal with the sanctions in Iran issues.
Thank you.
Well,
thank you very much. Well, as I say, I'm very grateful to your submissions, both the skeleton arguments and orally. It won't surprise you that I'm going to consider my judgment, and I'll therefore reserve judgment. Sorry, Mr. Duckworth, I should have asked you whether you want to say anything about costs.
Well,
Mr.
Lord,
Reed dealt with the costs.
Yes, I mean,
he's asking.
Mr. Reed made his submission on the basis that he won the case. We would say it turns on the outcome. If you discharge,
I assume you're saying costs should follow the event if you're
that's what I'm saying.
rather wholly successful.
Yes.
But
Yes.
there's two points really. One, Mr. Reed asked for costs on an indemnity basis, and secondly, if I were to come to the view that the judgment should be upheld, but only on the contract points, do you have anything to say about either of those positions?
Yes, I do. On the first point, I can't see any basis on which your lordship would award costs on an indemnity basis for the fact that the defendants have tried in good faith to intervene and engage in these proceedings. I can fully see the argument for indemnity costs where it's clear they're not engaging, but where they're making a bona fide attempt to become involved in these proceedings, that would not be the appropriate order. Your lordship would have to be extremely dismissive of the merits of their claim to consider taking such a course. It should be, if anything, and only on the basis of my learned friend winning his case completely, should it be a matter of standard costs. If it's, as your lordship said, a part and part judgment, so a score draw, one might say, in footballing terms, then the matter of costs should be reserved.
Yes, thank you very much.
Well, if I can come back briefly on that, there would be no purpose in reserving it. It's hardly clear to whom they would be reserved and what privileged position the reservee would be in. The position described by our lordship would not be a score draw. Essentially the immediate judgment would stand, and the application would therefore be dismissed, albeit with reasons essentially exculpating or saying that reserving the fraud issue to another day. But in those circumstances, we say that the defence of the contractual claims, there is no defence. There is obviously no defence. To the extent that it's been suggested, I don't want to rewrite my submissions, but we say that it is so clear that there is no ground of defending the contractual, even at this stage.
I'm asking you to repeat your submissions.
So we say even on the contractual ground that there is a basis for our application for costs on the indemnity basis.
Thank you. Right. Anyway, I was in the middle of saying I'm going to reserve judgment, and I'll let you have my decision in writing as soon as I'm able to reach one. Thank you both very much.
I will be very grateful to you sitting late.
Try and find a way of locking out.
At the bottom left corner of the screen, Judge.